my lord's list, my lord. And the
19.
90, my lord.
Ah.
This brings some precedence, my lord. But every day, my lord, new matters are being listed and the matter is going down in the list, my lord, in the PLA heading itself, my lord. My lord, because of the CIS system, my lord, new matters are being added and this serial number is going down, my lord, gradually, my lord. Some precedence, my lord.
What is the urgency?
My lord, we are unable to deal with the bank accounts, my lord.
90.
90.
90.
Yes, my lord.
Yes.
My lord's kind leave to mention a new matter, my lord. This is a non-contentious probate matter. My lord, it is defect-free ready. My lord, may it appear in the list. I'm grateful.
With your kind leave, I'd like to mention one PLA matter. This matter was listed on 10th January when your lordship was pleased to direct for citation, special citation and general citation. The issue is that there is only one legal heir, being the petitioner herself only. So should I do the citation on the petitioner? There is no legal heir other. This is a letter of administration.
What order is passed?
Only for citation, issuance of citation on 10th January. So should I, the department is also asking that on whom should we do the citation? So should I do it on the
Don't know. I
petitioner?
have to see the file, madam. I have to see the file.
Kindly, it is 636 of 2022.
Give the number, it will
Yes,
status to be
I'm
mentioned.
giving the mentioning.
To mention one
Matter.
matter, my lord, with regard to the matter relates to the construction of a dwelling house in terms of the sanction plan. My lord, due to passage of time, my lord, and the matter was hanging in the list. My lord, the plan of the panchayat will be, my lord, expire within a span time. Would the lordship take up this matter, my lord? The matter was
What is the
serial number 389.
What is the urgency?
Urgency is the sanction plan for the period of 3 years. That was, my lord, sometime, my lord, next month will be expired.
Oh, the next month, in the meantime, the regular judge will come.
What happened, lordship, my lord, the erection of a house, my lord, it will take some time. If we started, we have seeking a direction from your lordship that some obstruction may not be cleared. Your lordship, kindly give some preference, the matter can be
There is no only urgent, yes.
One non-contentious PLA matter. Non-contentious PLA matter.
One PLA matter.
Lordship, tell that just we try my luck.
Your time is there, the regular bench will come and you move before the regular.
Sorry.
I don't find any urgency, sir. Sorry. Yes.
Lordship, kindly one PLA matter, Lordship, one property situated outside of the West Bengal, Lordship. I am paying for the leave of the court.
It is listed?
No.
Give the list.
May I be permitted to mention, Lordship, 2 non-contested PLA matters. I'm praying for inclusion in the list. I'm grateful, Lordship.
May I have your Lordship's leave to mention, your Lordship, I'm in the process of filing a probate application. There are 2 of the legal heirs, they reside outside. One resides in Delhi and one resides in Gujarat. The affidavit of consent has been affirmed and notarized. Now, when I went ahead to file the same, kindly has a look on this. Your Lordship, the department says that right below day of April, solemnly affirm before me and will sign. This is provided by the notary officer himself. Your Lordship, the department is not accepting this, but it has been done in accordance with law. So kindly grants me leave to file the same.
It was notarized on 11 June.
Yes, Your Lordship.
2024.
Yes, Your Lordship. Your Lordship.
When your client has, when the witness, the executant has filed this, affirm this affidavit.
11 June, Your Lordship.
So why,
it was sent.
Why not put the signature date, or why the signature on 4th April 2024?
No, Your Lordship, I have sent the affidavit of consent from here to get it affirmed. The legal heir for some reason couldn't affirm at that time. It was with him. He got it affirmed, notarized, and sent back to me in the month of June, Your Lordship. So what the department has told me is it has to be done the way it has been done in Gujarat. And it kindly has a look the way the stamp has been placed here. But Your Lordship, in Delhi, the same stamp was not available with the notary officer, so he has typed it. Solemnly affirm before me and will sign.
No. It is attested. Notary, it is attested. It is not affirmation.
But Your Lordship, I explained the same to the notary.
Kindly see the notary book. There is a procedure how the notary stamp is to be attested. The affirmation.
So I shall have to send it back.
This is the affirmation seal. It is provided in the Notary Act itself. This round seal is the different, and with regard to the affirmation seal, contents read over and explained to the deponent in English or Hindi language, that will be the seal of the notary.
Okay, grateful,
That's
Your
why the
Lordship, I shall-
department is not accepting.
Okay, Your Lordship, I shall do this. Grateful, Your Lordship.
Your Lordship, may I be permitted to mention a matter? In PLA number 300 of 2024, we have filed an amendment application.
Hmm.
Your Lordship, if it may be listed in the list tomorrow or any day convenient.
Your PLA is in the list? No.
No, Your Lordship.
Give the number. Give the number, it will be
Yes.
listed.
Lordship,
GA number has been assigned.
Yes, Your
GA
Lordship.
number is
GA
assigned.
number.
Give the GA.
Lordship, may I be permitted to mention one Panchayat matter?
What is the urgency?
Lordship, the Sabhadipoti has died more than a month ago. There is a statutory obligation of electing a Sabhadipoti within a month, but he has not been elected.
When the Sabhapati died?
Sabhapati died, Lordship, more than a month ago.
More than a month ago. So why
Lordship.
you are not mentioned before the regular court? Wait for the
Lordship,
time.
Lordship,
10 days,
Lordship,
sorry,
statutory.
no urgency. Yes.
And for the deponent, Your Lordship.
This court find that the suit filed by the plaintiff is a commercial in nature. Accordingly, plaintiff is returned to the plaintiff with the liberty to present before the appropriate court.
This is kept as to be mentioned to fix any day for the final hearing. This is that defamation damages suit, Malad.
Acha.
The other side has filed their written notes of arguments. I had
They don't
taken,
want to
I had
argue the
taken
matter.
some time to prepare. Our notes are nearly prepared, but any day your lordship keeps it next month.
They are non-commercial.
Yes, non-commercial. It's a suit for damages when
Date, concert date. होगा.
any day at 2 p.m. or 3 p.m.
11:30? 11th
Whichever day.
concert date. 14th Feb. 14th February, 11:30.
Yes. Great.
The matter is listed as to be mentioned. Full list of counsel for the plaintiff press for fixing the date for hearing argued the matter. In view of the submission made by the counsel for the plaintiff, let the matter appear on 14th February at 11:30.
Great.
Look, this has come up at my instance, Malad.
Yes.
I had furnished a judgment, Malad, of a coordinate bench, Malad, with regard to whether Malad, it has to be in the name of the secretary or not. Malad, we have also found, Malad, this I had handed up to your lordship. I had also given it to my learned friend.
वाला ऑर्डर कुछ दिन दिए थे कहाँ रखे मैंने तो
And my lord, we also have now a division bench judgment, my lord. I have given them a copy. I am handing over to your lordship. My lord, division bench judgment, my lord, kindly see para 8 and 9. Kindly come to para 8. Now we are faced with the question as to whether suit could be treated to be in order because the suit filed in the name of the society and not in the name of the president or secretary. Well, it was one step higher. In order to examine the question, it would be necessary to deal with the scheme of section 19 of the 1961 Act. The object and purpose of incorporating section 18 and 19 of the 61 Act is to enable a society to act through its office bearer or governing body. It is a legal fiction that has been created so as to impede some person owing responsibilities for the society. It is a safeguard against the society to protect the interest of the society, or else no one would have been able to defend the society and anyone could have sued in the name of the society. Therefore, to protect the interest of the society, the authority has restricted only to the governing body. Therefore, the question that has to be looked into is whether it is governing body which is suing or it is representing the society in the proceeding itself. Then, the framing of section 19 of the Act starts with the expression may. The word may sometimes is interpreted as mandatory. Now it is to be looked into whether the word may used in this section is mandatory. Mr. Banerjee has relied on so and so. In the said decision, the division bench had held that under subsection 1 of section 90, every society may sue or may be sued in the name of the president, secretary, or any office bearer of the so and so in this behalf. In view of section 19(1), the society itself has no locus standi to maintain an action and consequently a writ petition. It appears that the said decision was rendered without examining the scheme and the scope and ambit of section 19, for which section 18 and 19 was incorporated in the act itself. If we examine the scheme of 19, it appears subsection 2 states no suit or proceeding shall abate by reason of any vacancy or change. Then 19(2) is declared. Next sentence. Therefore, it was not the president or secretary who were the real persons to continue or maintain the suit. It is the society which is interested in the suit for whom the president or secretary was acting. Subsection 3 of section 19 provides every decree or order against a society in any suit or proceeding shall be executable against the property of the society and not against the person or property of the president, secretary, or office bearer. Therefore, it is not the president nor the secretary in their individual capacity that is being sued. Well, this is what I am emphasis on. Not in their individual capacity is being sued. It is the society which is being sued through its governing body. In other words, society is the principal and the governing body or president, secretary, or authorized office bearers are the agent or attorneys of the society. There is a distinction between principal and agent. We cannot confuse the two. Therefore, we cannot interpret the word may in section 19 to be mandatory so as to preclude the society to sue in its own name. Well, in fact, this ratio is that society can sue even by its own name. It can either sue in its own name or can nominate its president or secretary for suing. As pointed out by Mr. Dutt, the plaint was signed and verified by the constituted attorney with regard to which there is no dispute, nor there is with regard to the authorization or ownership of the property as held earlier. The provision of section 19 being permissive, the society can sue or be sued in its own name. Therefore, the suit filed in the name of the society is competent and maintainable. In support of our view, we would refer to the decision of Navadvip Bhajanashram versus Commissioner of Navadvip, AIR 59, Calcutta, in which the division bench of the court had taken a view that society can sue in its own name. We agree with Justice Bhagwati in the construction put by him on section 6 and 7 of the Societies Registration Act, namely the provision contained therein for institution of suit by or against a registered society are not mandatory and do not militate against a registered society suing or being sued in its registered name. In the absence of any express provision in the statute barring the institution of suit by or against, Lordship will recall I had said that it is not under Order 7, Rule 1D, it is under A, the judgment of Justice Jyotirmoy Bhattacharya. Society, the first para of Rule 17 cannot be held to be ultra-virus. We accordingly hold that suit as framed was maintainable. Then my lord, Sonar Bangla was discussed. Kindly turns over. My lord, in fact, in Sonar Bangla, trial court had dismissed the suit, my lord. The appellate court rested it. I am unable to accept this argument. I am of the opinion that section 6 of the act uses the word may and therefore it is not mandatory but permissive. The language of the proviso to section 6 used express it shall be competent. It is only an enabling provision. It does not mean if the registered society sues as such, then it shall not be competent, even if, it shall not be competent. Defect, if any, on this point is cured by the fact that the secretary of this registered society, namely the Calcutta Engineering College himself, entered appearance and filed written statement on behalf of the registered society. Secretary is one of the persons mentioned under 6 of the Act. The view that I am taking, section 6 of the Societies Act is permissive and not either exclusive or mandatory, is supported by the decision of Justice Bhagwati of Siddhans. And then the other cases have been discussed.
Yes.
And Miller, kindly take Justice Shorkar's judgment. And in fact, this division bench was not considered by Justice Jyotirmoy Bhattacharya. That was not even the issue. Because ultimately, Justice Bhattacharya's judgment would reveal plaint was rejected on Order 7, Rule 1A. Non-disclosure of cause of action, I have shown that paragraph.
Yes.
Not under 1D. And Justice Shorkar's judgment, 28th August 2023.
Yes.
Internal page 2. Kindly come to the third paragraph. Dealing with section 19 of West Bengal Societies Registration Act, the court held, this was the order impugned. Court held that the suit had been properly framed and the club represented by the society was properly impleaded. That it was sufficient to sue the club through its secretary, which was a society under the Societies Registration Act, and all members were not required to be impleaded. This was what trial court had held. Now, this was challenged. Now, kindly come to Lordship will come to internal page 4. In fact, the revisional application failed. It did not interfere with these two findings. No separate discussion, but it did not interfere with these two findings.
Yes.
But the division bench now,
Clear.
we were troubled by this. I did not want to be run over by a bullock cart, but
My learned friend finished his argument in July. These cases were not cited, though the point was exactly that. Now, my first contention before I begin, my lord, to reply to this, no affidavit in opposition has been filed to my petition.
Yes.
In July, he finished his argument. I finished last week. Your lordship has made it CAV.
Correct.
Now, two decisions. First, as far as this decision is concerned,
Yes.
this I've read, the Justice Sharka's
Correct.
my lord will see page 2. Exactly the portion my learned friend
Which
read
one?
out.
Justice Sarkar order?
Yes, that's revision order.
Yes, yes.
Page 1. One was the point was the suit was barred under section 19.
Yes.
The page 1. Then page 2, the third paragraph, dealing with section 19.
Yes.
The court held that the suit had been properly framed, represented by the secretary, was properly so he was represented by, we don't know in the cause title whether it was written secretary or it was written Mr. Bose, Mr. Ghosh, whatever it was. So it was represented. So it is sufficient to sue the club through its secretary. Of course it is, but in the name, the section says in the name of the secretary. In our case, it says through secretary. In my learned friend's plaint, secretary is not the name of the secretary. I'm assuming. Of course, there might be a Mr. Secretary, but that is not the intention. They have said through secretary. Now, why is it that it is through a secretary? This other decision of the division bench was just given to me. I'll consider it. I'll try and answer that.
You both also consider
I want one
2003 volume 8 SCC.
My lord, there, 401.3. Now that is why. Why is it? I was also thinking, why is it has to be through secretary?
Because
the
that,
society,
in that case, all the societies,
yes,
several states act has been
and
considered.
it says that a society is not a juristic person, whether registered or unregistered. A society is a unincorporated association of people. Now, the case before Justice Sharkar, the argument appears to be that all the members should have been. My lord sees paragraph 2, the page 2, which was read. It is sufficient to sue the club through the secretary, which was the society under the Registration Act. And all members were not required to be impleaded. So all members are never required to be impleaded, either president, secretary, or an authorized person.
Any member of the governing board.
Now, my learned friend had argued that day, of course, without relying on this judgment, which he hasn't cited, the division bench judgment, he had argued that every time the secretary changed, do I have to change the name? Perhaps you will have to, but it doesn't abate. But it has to be initiated in the name of a living person.
Okay, consider this.
My lord, this judgment, then my learned friend can also come back and 2003, 8
That's
SCC,
also taken into consideration.
413.
Yes.
But it's very clearly explained what is a juristic person and what is not. And the Supreme Court has held that it has to be in the name of. So Justice Seth's judgment, the division bench, I'll consider it whether it is truly on the point. There are decisions both ways, but this is something your lordship will have to decide. But as this and the decision relied on by Justice Sharkar, my lord, the Syed Ayaz Ali. There it says that if an Order 7, Rule 11 is decided, after that there is no question of trying to cure. So my learned friend, on notice from July, he's been arguing he has not tried to cure this defect. And it is once your lordship decides the Order 7, Rule 11, there is no question of him getting leave to cure the defect. If, of course, I am correct, and
No, then again the question will be whether the
they will file a separate suit, new suit they can file.
mere not implementing the by name or whatever it
Yes.
can be called, whether it can be deemed, whether the suit can
Whether
be
it's barred by law
barred
or
by
not.
that is
Yes.
also to
That is, I think, in Ilaichi Devi.
Milachi Devi has considered that.
It's considered.
Devi had considered.
So then your lordship keeps it tomorrow or any next week sometime.
This is a commercial, no?
I will tempted to give notes, but I don't want to fall into the note because he hasn't filed an affidavit. Now his note will become his affidavit. But it's a
So and so suffering for the plaintiff, so and so suffering for the defendant. Though the matter was concluded
let a copy of it.
with respect of concluded with respect of GA देख लेना क्या है GA, and this court has fixed for CAV, but in the meantime the learned counsel for the plaintiff intend to draw the attention of this court two judgments passed by the Honorable Division Bench of this court and the coordinate bench of this court. The learned counsel for the plaintiff has cited the said judgment. Learned counsel for the defendant prays for time to fix another date to give appropriate reply to the said citation.
My
Court
your
also-
lordship may also record that I've given him a copy
Counsel
of
for
this.
the defendant also relied upon the judgment in the case of judgment reported in 2003 volume 8 SCC 413.
Yes.
Has also handed over to the learned counsel for the plaintiff. Both the parties are directed to consider all the judgment. Let the matter appear on. कब है 11 बजे कुछ फाइल खाली है नहीं है नहीं ना फिर टाइम हो जाता 7 तो नॉन कमर्शियल डे 11:30 खाली है 7:30 11:30 7th February 11:30 7th February 11:30
Wait.
number 7
Name of secretary, not by his personal. The administration chief. Item number 4.
उसको निकाल के इसमें डाल देना
Well, in this matter, we have filed notes of arguments and we are
Item
for the
number?
petitioners. Item number 4 and 5 together, my lord. We have filed our notes of argument. Today, the respondents are supposed to file a notes of argument. It was Order 12, Rule 6 application, my lord.
My lord, we're filing our notes.
And a copy.
হ্যাঁ খুলে দিচ্ছি আপনি বোধহয়
Both the party filed?
দেখছেন
you also filed
I filed.
you are appearing for
I am appealing for the respondents, my lord.
the matter is
Substituted respondents.
the matter so and so appearing for the plaintiff so and so appearing for the substituted defendant full stop both the parties have filed their written notes of argument CAV in connection with both
No, my lord. Your lordship's pleasure was we should file two separate note. So in the second matter, I am filing a separate note. Same, my lord, same points, only the claim amount. হ্যাঁ দিচ্ছি এই তো রাখা আছে আপনার জন্য
CAV
claim amount are all different. The names are different.
okay
Item number 6.
Lord, I appeal for the defendants. Lord, I have taken out an Order 7, Rule 11, my Lord.
who is for the plaintiff
They are not here. Now, my Lord, I'll also be taking out an application for, my Lord, the extension of time to file my written statement. We have prepared it. Lordship keeps it after 2 weeks. In the meantime, I'll file the application. Lordship will then take it up together with the main GA as well as
Order
my
7
Lord,
Rule 11 GA2
GA2 is Order 7, Rule 11.
My Lord, I appear for the plaintiff. My
Ah.
Lord, this matter has appeared on my instance. I had mentioned the matter. My Lord, they have filed the Order 7 Rule 11 application, but I want to use an affidavit to the said application. Let affidavit directions be passed, my Lord, if your Lordship fixes a date for hearing of the Order 7 Rule 11. My Lord, that.
In the meantime, I'll file my application for extension of time to file the written statement. Want to give an opposition
so
reply?
and so appearing for the plaintiff so and so appearing for the defendant full stop the defendant has filed the Present application being GA2 of 2024 for rejection of plaint.
Yes, my lord, rejection of claim.
For rejection of plaint. Full stop. Counsel for the plaintiff press for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks, 3 weeks.
2 weeks.
Within 2 weeks.
1 week thereafter reply. my lord.
Reply, if any, there to be filed within a week thereafter. Full stop. This is the matter on 26th February
Grateful.
under the heading adjournment motion. Next.
My lord, there is a direction to for citation, my lord, special citation and general citation, my lord. Subsequently, department pointed out there is a caveat, my lord. My humble submission, my lord, that direction may be given to service to the caveator. My lord. Only one legal years file the caveat, my lord. My lord, there is. I am praying for direction upon the caveator to serve note. As well as the special citation and general citation, and also the caveat.
There is a direction. B and C, what is the direction? Press for issuance of special citation, general citation. Have you issued?
My lord, I have given, the department pointed out, kindly issued notice, direction may be given to the, issued direction upon the caveator service and also the.
There is no report. How the court can pass an order without any report?
Department pointed out.
No report is here. Department might be pointed out to you. On your basis, how the court can pass an order? Tomorrow the department will come. There is no caveat. How the court will understand?
There is on the
You
department.
are acting upon the department. You act upon the department,
No,
not
no,
today. Next.
I'm good.
My lord, I am for the defendants number 1, 3, and 4.
Yes.
I'm for the defendant number 2.
GA,
The plaintiff in this. Number 5.
my lord, GA1 is my application
For
seeking extension of time to file written statement. My lord, on 19th December, my lord was pleased to grant time up to January 16.
Hmm.
We have taken out this application for extension of time to file written statement. My lord, kindly, sorry, my lord.
You for the defendant 1.
1, 3, and 4.
1, 3, and 4.
GA number 1 is my application.
And you are appearing for?
Defendant number 2.
2.
5. Defendant number 5.
You are 5. You all file affidavit, written statement?
My GA number GA2 is there lots of similar application for filing written statement extension.
GA1, GA2.
Got it.
You are not file any.
For me, I had not given consent to become a trustee. Now I believe that is accepted among all the plaintiffs and the respondents. So my name rightfully should be deleted from the proceeding.
My lord, we have issued a notice of meeting. Meeting is supposed to be held on January 25. My lord, his name will be removed. My lord, we have, I believe my learned friend has also been served with the agenda and notice of meeting. My lord, will see my lord's order, which is at page 7. Time was granted up to January 16, my lord. We have moved this file this application before January 16.
Chapter 13.
Yes.
My lord, this application is not maintainable.
Which one?
Both the applications for
extension of time.
Extension of time.
Why?
My lord, under the rules, there is no provision for filing of a written statement.
Yes.
My lord, may I draw your lordship's attention to the
So
chapter 13.
You challenge the order, my order.
No, my
This
lord.
court has directed to file the written statement.
My lord, assuming there is an order, if it is contrary to the rules.
Yes, so the rule.
Yes, my lord. This does not provide for rule said Buini.
Which rule? Which report?
Chapter 13, originating summons.
Yes.
My lord, if you take rule 1, G. 1 G.
Determination of any question arising in the
Administration of the state.
Correct.
Now, question is, there is no scope under this chapter for filing any written statement in a originating summons proceeding.
So what is your prayer in the CS?
If your lordship takes my
opinion as
prayer, my lord,
also?
This is not a normal suit.
What is the opinion you ask for?
If your lordship takes the judge,
Whether the judge
summons, my lord, whether under the trust deed, the trustees of the trust estate of Bhagwan Devi trust have right to appoint any trustee not being a member of the Poddar family.
Correct.
That the document itself will speak. Then, whether in view of the present physical condition of the defendant number 1, he should be allowed to continue as a trustee to the detriment of the trust. Here there are proof. I have annexed copies that he is not in a physical condition. If your lordship wants, your lordship can appoint a doctor to find out the position. Then number 3, whether Vikram Poddar, Arun Poddar and Abhijit Poddar or any two of them may be appointed as a trustee in view of the embargo in the trust deed for appointing trustees of not more than 5 at a point of time. This is also a question to be determined without any affidavits. Whether in view of the impasse created by the defendants in operation of the bank account, this is a discretionary order that I have prayed for. It is entirely for your lordship to decide whether it should be allowed or not. Therefore, my lord, if the provisions of the rules does not provide for filing of any written statement and the questions framed does not require any affidavit to be filed, your lordship will dismiss this application and hear out my application. Now, my lord, one more thing, my lord. Take CPC to the Section 129.
Yes. Yes.
Section 129, my lord.
Correct.
It gives power to the High Court to make rules as to their original civil procedure.
Correct.
And civil procedure code provisions are excluded. The High Court rules will prevail.
Correct.
Therefore, my lord, the ordinary rules of a suit being filed.
Where the rule says the originating summons suit, the opportunity and the written.
Yes, my lord, that your lordship will kindly see.
13A, 1A, 4 trust. It is only by affidavits. 9 leave to defend. Their application has for leave to defend.
My lord, if your lordship takes rule 1, my lord, read with
Chapter 13A.
Chapter 13A, rule 1, and
1A,
and rule 5.
1A, 4 relating to a trust. 4 is filing by
Chapter 13A.
And rule 1, read with rule 5, my lord. Affidavit shall state whether the defense alleged goes to the whole or part of an, if so, to what part of the plaintiff's claim, and the shall deal specifically with that matter of fact.
The affidavit shall state whether the defense alleged goes to the whole of
Yes,
the
my lord.
whole or part. Yes.
And they have
Therefore, there is no scope for filing any written statement.
they
That is what my submission before your lordship.
They accepted. Their application is under Rule 9.
Now, my lord, if your lordship takes rule 9, my lord.
Leave to defend may be given unconditionally or subject to.
And now, my lord, your lordship sees their prayer for taken out in the application. Live to defend.
Under Rule 9.
Under Rule 9.
Leave to defend may be given unconditionally or subject to such as giving security or time or the mode of the trial as otherwise.
That is their prayer A in the application for extension.
Correct.
If that is so, my lord, where is the scope for filing written statement? My lord, lordship can deal with it without going into.
But okay, if we go by your submission, if this court will go by your submission, what the question you ask for, this is the right of the other party. If the right of the other party is affected, whether the court cannot hear the other party.
Of course, yes, your lordship will hear.
Then if you're relying upon one document is not a fit and as per the medical, so they are not entitled to deal with the document.
Well, there are allegations regarding bank accounts also.
Whatever the allegation, it cannot be dealt with.
Of course they can. What is the allegation? Allegation
whatever
is,
it may be, once you have made a party, a person as a party to the suit, the person cannot be given an opportunity.
Yes, they will be given opportunity. That is Rule 5.
Yes. So rule 5. So if you are relying upon some document, so they cannot be entitled to give the contrary
I
document.
am relying upon that document means the deed of trust.
Whatever it may be.
That is their
No,
document.
you are
also.
telling that the medical certificate. Leave aside that the deed of trust. Only on the basis of deed of trust, I am deciding here in now.
Yes,
if you are not, if you are relying upon the medical certificate, then the court has to give.
Your lordship will decide on the basis of the trust.
So you are not relying upon the medical
Very well, my
document?
lord. Your lordship will decide on the trust deed.
Okay,
My
no
lord,
problem.
only in that respect, my lord, I will be humbly submitting. Only questions 1 and question 3 depends on the interpretation of the trust deed.
Correct. That's
My
what I'm
lord,
telling.
other 2 questions, my lord, cannot be decided in a summary
That's
manner.
why I told you, if you are not relying upon the other documents, so I will decide with regard to the
Very
deed.
well,
What
my
is
lord.
the deed of
1
interpretation
and
of
3.
the deed?
1 and 3.
1 and 3. With regard to the other, cannot.
1 and 3, your lordship will decide.
Correct. So you are not pressing this 2 and 4.
2 and 4.
You are not pressing.
Not pressing.
My lord will kindly record that.
Yes, I am recording. I am recording. If you are not pressing, then I will dismiss their application. I will pass. I will hear all the parties and I will pass a
Lordship.
appropriate
Lordship.
order. So and suffering for the plaintiff. So and suffering for the defendant number 1 and 3. So and suffering for the defendant number 1 and 3.
1 and 3.
1 and 3. So and suffering for the defendant number 2 and 4. And so and suffering for the defendant number 5. Defendant number 1 and 3 and 2 and 4 have filed an application being GA1 of 2025 and GA2 of 2025, praying for extension of time to file return statement. Full stop. Counsel for the defendant submit that by an order dated 19th December 2024, this court directed the defendants to file their return statement on 16 January 2025, but the same could not be filed. Accordingly, the defendants have filed the present application for extension of time to file return statement. Per control, an advocate appearing for the plaintiffs has raised objection and submitted that the application filed by the defendants is not maintainable, and submitted that in the originating summons suit, there is no provisions to file return statement, and as such, this court cannot extend the time for filing return statement. Counsel for the plaintiff has relied upon chapter 13 within bracket chapter 13 rule 1 within bracket F of the small f of the original site rule, read with chapter 13 capital A rule 1 within rule 5 within bracket A of the said rule, and stated that in terms of the said rule, no return statement is required. Full stop. Counsel for the plaintiff further submit that this the plaintiff has filed the present suit for adjudication of the issues as mentioned in paragraph 19, which reads as follows. Record this 19, page 12, 19. Full stop. This court has considered the issues raised by the plaintiff in paragraph 19 above, as mentioned above, and this court find that with regard to the issue number 1 and the issue number 3 are in connection with the trust deed of the trust with respect of the trust deed, but the issue number 2 and issue number 4 is with regard to the allegation upon the defendant number 1 and other defendants. Full stop. At the time of hearing of the learned counsel for the plaintiff submit that the plaintiff has having the document to show that the defendant number 1 and the physical condition of the defendant number 1 is not good, and as such he cannot be allowed to continue as a trustee. Full stop. But at the time of hearing of the application hearing of the parties, learned counsel for the plaintiff submit that he is not pressing the issue number 2 and issue number 3, and he is only pressing for hearing of issue number 1 and issue number 3. Full stop. Subparagraph.
Well, 1 and 4. The lordship.
2 and 4.
Two and
He is not pressing the issue number 2 and 4. And he is pressing is 1 and 3. 1 and 3. Full stop. Full stop. Considering the above, this court find that with regard to the issue number 1 and 3 is in connected with regard to the interpreting of the trust deed. Thus, for the interpretation of the trust deed, no written statement is required. Full stop. As the plaintiff undertakes submitted before this court, the plaintiff is not pressing for the issue number 2 and 4. 2 and 4. Thus, in view of the submission made by the counsel for the plaintiff, the application filed by the defendants being GA1 and GA2 for filing written extension of time to file written statement is dismissed. Let CSOS 6 of 2024 be fixed for hearing on 12th of February 2025 with respect of the issue 1 and 3 as mentioned in paragraph 19 of the suit.
Well, your lordship has fixed it on 12th February.
12th February. No, adjournment.
Please, my lord.
Yes.
My lord, the matter is coming up at my instance.
Item number 9.
Yes, my lord.
Yes.
My lord, an order was passed on 17 December in this PLA, my lord. My lord, inadvertently a submission was made on our behalf. My lord, inadvertently a submission was made on our behalf, my lord, that only one legal heir has filed the affidavit of consent. My lord, in fact, 2 heirs have filed their affidavit of consent. My lord, may I hand over the order of that date?
Order dated?
My lord, 17 December 2024. If
How
my lord-
many legal heirs are there?
My lord,
Where is the probate application?
My lord, there are 4 legal heirs.
4 legal heirs.
If my lord comes to page 3.
Yes,
My lord, there are 4 legal heirs. My lord, we have submitted that one legal heir, that is the wife of the deceased.
Counsel for the wife of the testator has filed the affidavit of consent, stating she has no objection or grant of probate of the will to the petition, but other 3 legal heirs have neither filed their affidavit of consent nor filed their affidavit of support.
Yes, my lord. My lord, my humble submission would be, my lord, that this would not be 3 legal heirs, this would be 2 legal heirs, because the daughter-in-law of the deceased has also filed her affidavit of consent.
Which daughter?
Daughter-in-law, Shashi Modi.
Shashi
Modi, an affidavit of consent dated 25th October 2024.
Shashi Modi?
Yes, my lord.
ये मनतोष देखो शशि मोदी का है क्या? शशि मोदी का होता क्या नो गया बेटे? Yes.
My lord, Shashi Modi has also filed her affidavit of consent. So, my lord, in the order dated 17 December, perhaps, this correction would have to be incorporated, my lord. Now, the wife and the daughter-in-law have filed their affidavit of consent.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner submitted by an order dated 17th of December 2024 This court has granted probate to the petitioner. Full stop. Counsel for full stop. He submits that after going through the order, the petitioner find that in page number 1, One, 2, 3, 4, 6, 7, 8. In paragraph, in line number 8, it is recorded that no. In line number 10, it is recorded that other 3 legal heirs have not filed affidavit of consent, nor have filed their affidavit in support of caveat. But the counsel for the petitioner failed to brought to the notice of this court that one of the legal heir of the testator, that is Shashi Modi, who is the daughter-in-law, had also filed her affidavit of consent stating that she has no objection for grant of probate dated 14th August 2019. Accordingly, counsel for the petitioner prays for correction in the order dated 17 December 2024 by incorporating a sentence that this daughter-in-law, namely Shashi Modi, has also filed her affidavit of consent for grant of probate. Heard the learned counsel for the petitioner peruse the record. This court find that in the record there is an affidavit affirmed by Shashi Modi is available. Affirmed by Shashi Modi dated 25th of October 2024 is available, wherein in paragraph 6 she has stated that she has no objection for grant of probate of the will dated 14th August 2019 in favor of the petitioner. In view of the above, in page number 1, in line number 10, line number 9, 8 karo. Line number 8, it may be recorded that after line number 8, after the word the wife of the testator and the daughter-in-law of the testator have filed their affidavit of consent, and in line number 9 it may be recorded, but instead of 3 legal heirs it may be recorded as 2 legal heirs. Okay. And in page number 2, paragraph 2, line number 3, affidavit of the word wife of the, after the word wife of the testator, it may be recorded, also recorded, the daughter-in-law of the testator. Okay. This order may be incorporated with the order dated 17 December 2024.
Lord, wherever your lordship has dictated Shashi Modi, Lord, perhaps Shashi Manoj Modi would be more appropriate, Lord, because the affidavit is in the name of Shashi Manoj Modi, also known as Shashi Modi.
Shashi Modi alias Shashi Manoj Modi. See the affidavit. In your the petitioner you have mentioned as Shashi Modi, and in the affidavit you have stated both, also known as Shashi Modi.
Grateful, my lord.
The plaintiff, my lord, mentioning served its purpose.
Yes.
But she was kept it as to be mentioned. Yesterday at 5 o'clock, they gave us all the affidavit.
Item number 10.
Item number 10. They've given us the suggested issues also. We've also prepared ours, my lord. These are the suggested issues which we prepared. That I'm okay with all of theirs. I don't want to waste your lordship's time, except issue number 3.
You are for the plaintiff.
I am for the plaintiff. The
Who is for the-
suggestion issued by the defendant.
Hmm.
Yes, is accept it.
Also, I'm filing the citation. I'm led by Mr. Kamakar. I'm led by Mr. Kamakar.
কোনটাতে কি হলো মিস্টার কর্মকার ইজ ইন দ্য কার
থাকো তেরোতে কি হচ্ছে What is the suit for?
The suit is with regard to election of certain members of this association, where in respect of the articles of association, certain members can be eligible to vote, certain can't be. So the electoral vote, the election that's been prepared has been based on the voter list. That voter list has added people who are now out, who are not eligible. And the election has been held. That election has been challenged. The next one is again in September 2024. So that was the urgency. Now the 2025, sorry. Now the issues have come out. My lord, except issue number 3 suggested by the defendants, I'm okay with all of them. My lord, Lordship, we can.
Are the plaintiffs in present name lenders of the
Plaintiffs in CS number? There is one line in one paragraph of the written statement. That too is restricted to one plaintiff, number 7. So with regard to all the plaintiffs, this is not an issue in the suit.
But that will be one of our major point of challenge.
Pleaded
Lord,
it.
because our entire one of our base of the claim is that they are name lenders of the previous litigation.
Well, let him show that one pleading.
But that will show.
No, it's framing issues. It has to be there in the pleadings.
Where is the
Otherwise, it can't be. This is not an issue of law.
But,
Paragraph 5, there is only one pleading, my lord. Paragraph 5 of the written statement.
that is good enough.
Well, I'll show it, Mr. Kormakar, 1 minute. It may not be enough, my lord, because it's not with regard to all the plaintiffs and with respect to the.
Have you filed the written statement?
Statement has been filed. Lord, written statement has been filed, Lord.
When?
Copy file
Mr. Mukherjee, please indicate.
You are having the copy? Written statement?
When has he filed it?
Which paragraph you have taken the plea of the issue number 3?
Paragraph 5, your lordship will see.
I am not having the written
Oh, I'm so sorry. Kote daoni? Jama file koroni? No.
Lordship, it has been filed in the department, the written statement, Your Lordship.
You are having copy?
I have only
Yes.
one copy.
Show me which paragraph with regard to the issue number 3. Which paragraph you raised this pleading?
May I share my copy, my lord? Kindly have a look at paragraph 5.
Your Lordship, if I may. With reference to para 1 to 8 of the plaint, the allegations contain. I will read from the.
It is stated.
It is stated that the plaintiff number 7 in the present suit is the son of plaintiff number 1 in CS number 224 of 2021 and has filed this suit as his name lender, namely Milan Bhomik.
So just with regard, that's it. That is all that is there. So just with regard to one plaintiff as a name lender, his issue, he has made it much wider, as if all plaintiffs are name lenders of the previous.
So it may be.
This can be modified to either I don't mind.
Plaintiff number 1.
Yes, only plaintiff number 7.
So 7. No, 1.
No, plaintiff 7 here. Plaintiff number 1 there.
Okay. Plaintiff number 7.
Yes, because he's not raised the issue of other plaintiffs being name lenders.
So what is your other? Suit is maintained barred by provisions of Companies Act. Companies Act.
Companies Act. No, this is already a settled issue, but he's taken the pleading.
Election held on itna be assailed on the basis of report data itna. The plaintiff entitled to challenge.
Well, this is not settled, my lord. Indicate why.
Entitled to any relief.
So, Mr. Kormakar, if you agree, we can do away with number 2.
Number 2.
If you also agree,
No, it's not settled. But I feel it's not settled.
Not settled. Not settled. Very well.
He's telling not settled.
Then let it be there. Okay.
You have made the joint administrator as a party?
Yes.
Defendant number 25 and 26.
26, yes.
Or he's framed it like this. He's taken the pleading, so I can't really have a problem with it. But that's not what my suit is based on. So along with my issues, if it comments to this court, his 3 can be modified and the rest can come in. So we can say
I am taking the all of the plaintiff,
Yes,
only
yes,
the plaintiff instead of plaintiff number 7.
7. Rest all the issues can
And
be
I am
there.
taking your even the total.
Yeah, we've given quite a few.
Whether the executive committee has been discharging its fiduciary duties towards the association. How it can be?
Lordship is looking at blood.
12 and 13.
Yes, Lord, we have pleadings with regard to this. What has happened is, so this body comes in and they start renting out these particular assets or properties of the association at a value which is much at throwaway prices. And there's complete mismanagement of finances and mishandling of the assets of the association. And that's a specific pleading in the suit. We have evidence also to back it up that what he's doing is completely contrary to the articles. And the article also tells them how to go about dealing with these assets that they've not done. It could have, your Lordship is right, it could have been covered under one omnibus. But because we've separate evidence also and pleadings with regard to that, we thought we'll add 13, 12 and 13.
Yes. So and so appearing for the plaintiff, so and so.
Your Lordship, may I file the admission and denial and the affidavit documents before the court, Your Lordship? Your Lordship, one small issue, Your Lordship. They also have to file the judge's brief of document before the.
So you've given the affidavit today.
Your Lordship, we had asked for the
Plaintiff, appearing for the defendant. Both the parties have filed their affidavit of documents as well as suggested issues. Let the
admission denial.
Admission and denial and suggested issues. Let the same be kept with the record. Full stop. Consider the submission made by the counsel for both the parties, and the pleadings. The following issues are framed. ये सब आ जाएगा 14 and इसमें खाली ये भी सब आएगा खाली plaintiff number 7. ठीक है full stop. The plaintiff is directed to file the judge's brief of document within 3 weeks from date after serving the copy to the learned counsel for the defendants. Full stop. List the witness.
A week thereafter, my lord.
List the matter. Give the witness action or commissioner.
Commissioner would be better. Lord, I would prefer a commissioner if your Lordship allows that. Then it can actually will save your Lordship's time. It can move much faster.
Yes, Mr. No, he left.
He's in the car. He won't oppose it.
Okay, within 3 weeks, bola na?
3 weeks.
Let the matter appear on. आज कितना तारीख है? 22nd. Let the matter on 20 February. On that day, required, then I appoint. Because Mr. Kaur is yes, can appoint.
I'm taking instructions.
Why would you oppose a commissioner? You say
No, I am not opposing, but I have to take instructions before I can. Because Mr. Kormakor is not answering. That's why, Your Lordship.
Okay, come on 20 February.
Lord, could I come on the 12th? The 3 weeks expire on the 12th.
12th.
So
come
by
on 13th. Come on 13th.
13th will come back.
13th February.
Very good.
Take the instruction on that day.
I will oblige, Your Lordship.
Lord, may I take back the written statement, Lord?
हाँ? हाँ, हाँ. इसको हाँ 2 minutes. नहीं for orders करो.
Written statement. Thank you. Wait.
Yes.
In this matter, I am for the defendant numbers 1 and 2.
Lordship, the goods could not be removed because the locks were there.
Initially, they had said that they will allow the locks to be broken. This is the minutes of the order. This is in paragraph 3, they are allowing it. And then later on in paragraph 6,
Who is the commissioner?
Commissioner was here, Your Lordship. She was here.
Special officer.
Oh, there she is. You come here. You come this way. Come.
Yes. What is the problem?
Your Lordship, the suited premises is a two-story building, and it's a mall, shopping complex. So, in first instance, it was said that when I asked the parties, the plaintiff denied of having any key. So that the defendant, because as they have already mentioned in their affidavit in opposition to the injunction application, as mentioned
What
by
do you want?
Your Lordship, in today's date, if you see, the two premises would need at least 2 to 3 days minimum to remove all the goods. On top of that,
Whether the lock was open?
there were 4 locks, there were shutters, there were 4 locks.
Why?
With leave of Mr. Mentor.
Yes.
The Lordship's order was very clear.
Who is for the defendant?
My lord, I am for the defendant.
Yes.
And
My lord, I have categorically stated in my affidavit in opposition to their injunction application that they have kept the premises under lock and key since
Okay, you do one thing. I am fixing tomorrow. Whatever the key is available, bring to the.
My lord, we don't have any keys.
Yes.
Please, my lord, perhaps perhaps the learned special officer wants permission from your lordship because she has indicated in paragraph 6 specific permission so that she can break open the lock. That was agreed between the parties on that.
Yes, we don't have any objection.
And same was attempted as well, but there were 4 locks plus 4 shutter locks.
Who is having the key?
Lord, the landlord or owner should have the key.
How can we? Because we have rented the premises. We have let the premises in 2018, my lord. As per the agreement, they were running the shop, City Mart over there. Keys were with them. They did not. In 2018, my lord, agreement was entered into. From the next month, in July, agreement was entered into. They paid the rent for August only, and thereafter they did not pay a single. No, I must state these facts. We don't have the
So
all their goods are stay with them.
Your Lordship, one more request.
Yes.
With respect to if the instance, the whole exercise takes 2 to 3 days, in the meantime, while it is open, the owners of having the symbolic possession of the property, is it required as per your lord's direction? If it's open for 2 to 3 days, none of the parties were agreeing that day also, if at all we break open, to keep the keys with them.
No. You have to keep the break open. After the work is over, it is not completed. You put the lock and go. And second day you come, inform the date. They will come. Whatever till all the articles has not been removed. Then once the articles has been removed, then hand over the possession to the owner by giving him writing in the minutes of the meeting.
Well, Lordship, with that, can we just direct?
This is the way.
So suffering for the plaintiff, so suffering for the defendant, and the special officer appointed by this court is also present. And the special officer submits that the premises in question having 4 locks.
Total 4 locks and 4 shutter locks. Total 8 locks.
So how the shutter lock will open? This is inside the key.
The special officer can approach any key man who can take steps to open it.
Your
It is a process.
Then it will.
Landlord is now taking a stand, which is
No,
quite
my lord,
amazing.
we have not taken a stand. I am very clear on my point that business was carried, possession was with them. How can I have the key? Because they were carrying on the business over there.
For the shutter lock inside, not the padlock.
Total 8
Padlock is
locks.
also there.
Total 8 locks.
Having
padlocks, 4 shutters.
क्या बोला? This
8 locks. I couldn't
having 4 padlocks
8 locks बोलेছে ना.
and 4 fitted lock with the shutter, 4 shutters. 4 shutters. And as such, 4 shutters, full stop. The defendant, being the owner of the property, has informed the plaintiff, informed the special officer that she is not having, the owner is not having the key. Full stop. The tenant has submitted that the key is with the owner. And as such, it is not possible for the special officer to open the premises and to complete the work as assigned by this court to the special officer. Accordingly, the special officer prays for an order to break open the padlock as well as the lock of the shutters so as to enable the special officer to enter into the premises and to take note of the to make inventory of the materials available in the premises and to hand over the same to the plaintiff. To the plaintiff. Full stop. Consider the submission made by the counsel for the respective parties and the special officer. This court also, one of the plaintiff is telling that he is not having the lock of the premises in question, and the defendant is also telling that they are not having the keys of the lock of the premises. And as such, this court is no other alternative but to allow the special officer, with the assistance of the local police of the said area, to break open the padlocks and the locks of the shutters by engaging any persons to open the key, to break open the padlock and the key and the shutter in presence of both the parties. Full stop. It is made clear that if any of the parties restrain the special officer to complete the work by opening the lock, the special officer is free to make appropriate complaint to the police authority, and the police authorities are directed that if any request is made by the special officer, the concerned police authority shall provide necessary police force to the special officer to execute the order passed by this court dated
2nd
January 2025, including the break open of the padlock and the lock of the shutter of the premises in question. Full stop. The special officer is directed to complete the work within
12th was the return.
To comply with the order passed by this court dated 2nd January 2024 within 4 weeks from date.
Well, may I pray for an injustice? Well, your lordship was returnable date was fixed on 12th, my lord. Can your lordship kindly make it after 14th of February if possible? Because
that automatically gets extended.
no, that I okay.
4 weeks. Let the matter appear on आज 22 है ना 20. This is a non-commercial. 26th February.
And there is another prayer I am making, my lord. Since the matter was in the list, there was direction to prayed for filing written statement, my lord.
What further remains?
No, in the main suit, because claim and counter claims are there. My lord, written statement is account within 90 days, but it was placed before the master for extension of time. But since my
let the application come. Let the application come.
Let the time be extended for filing. It is within 120 days.
30 days is over.
120
days is over?
No.
When you receive the writ of summons?
4th of October, my lord. Yes.
Okay, you do one thing. You file the written statement in the department subject to acceptance. Give the leave.
Grateful to your lordship.
अरे बात कम करो.
Grateful to your lordship.
Leave is granted to file the written statement in course of the day, subject to acceptance by this court.
Grateful to
Till the time this process is carried on, the special officer would be having a symbolic possession of the premise. That is necessary.
It is made clear that till the special officer has not made hand over the possession of the said premises to the plaintiff, the special officers shall remain in be in the possession of the property shall be in the symbolic possession of the special officer. Symbolic possession of the special officer.
No, it is
Yes, next.
Grateful to your lord.
Well, this is my application. If your lordship recalls for the orders that I was seeking, Mr. Datta was to get back with instructions, my lord, on this.
Contempt is not the special officer's application. Contempt is mine. There's
I stand corrected. My lord. The GA1 is my application.
This was
GA1 is
referred
my
for me to take instruction on his application, GA1.
That's right. That is
1,000
right.
or 15,000 to be paid to the
My
chartered
lord, I have
accountant.
taken instructions, my lord. They are saying, my lord, it should be a nominal figure, my lord. Even 15,000 per month is, my lord. So the work, considering the nature of the work that the, my lord, accountant is to do, it's only filing of forms, my lord. My lord, possibly that is, my lord, according to them, it's something more, my lord. If a reasonable amount can be, my lord.
What they are suggesting?
I don't want to quote a figure, my lord. I don't want to bargain with court. I leave it to your lordship. But
Court is not going to do anything.
my lord, they are saying, my lord, if lordship wants a figure, well, only on instructions I am submitting, they are saying it should vary anything between 5,000 to 7,000, not more than that.
My
That's
lord, may
per
I
month, if it is, my lord, required, this is the, my
He
lord.
stands as unreasonable as in the contempt proceedings. That's all that I have to say.
I don't
Today,
think Mr.
in
Bose,
today's world,
Mr. Bose has any
somebody
say,
will do with
because
5,000.
it was for me to come back.
Lion's share. He
My
has
lord,
the lion.
may I correct Mr. Datta? Your lordship will kindly take page 18 for a moment. My lord. Part B is what is required to be done by the gentleman concerned.
Special officer.
And as Mr. Bose says, my lord, the figure of 5,000 or 7,000 is
Page.
page 18, my lord, 18.
Yes.
Part 2 is
Why I
what we are
didn't want
really
to quote a
concerned.
figure. That's
Part
why.
2 is what we are really concerned, my lord. It is not
20,000.
simply filing. It is even the accounting part and filing the returns. The maintenance
Part
bills
1 is PAN 10 and GST application 15,000. That's not dispute.
That's one time.
that
That's not an
that
issue.
has been
And that has
done,
been
my lord.
paid,
That is
I think.
complete.
Okay. Only
That
will
has been done.
20,000 per month.
Yes.
That's right, my lord.
My lord,
That
he
is the
agreed to 15,000. This is the, my lord, ballpark figure I
very well,
have
my
in
lord.
mind for my client, and I
will
leave it
not
to my lord.
I will not grind an axe, my lord. Your lordship will kindly fix it at 15. I will not grind an axe on this. I will leave it
A
entirely to you.
person who in occupation of more than 1 lakh square feet on Chaurangi Road, commercial space, is saying chartered accountant should be paid 5,000 rupees for doing this work.
My lord, I'm very sorry to say this. Mr. Bose is trying to, my lord, take aid of the, my lord, alleged act of contempt to say that this gentleman will have no say in any application henceforth. This is not correct.
Says are so
My lord, kindly visualize the
dramatically
situation.
unreasonable.
No, kindly visualize the
20,000,
situation, my lord.
15,000 we've said. Now he comes and says 5,000 rupees.
My lord,
So basically he wants that nothing should be done in the building.
Okay.
And everything should come back to him.
My lord, may I make one
Let the
submission?
court be decide. Let the court be decide.
My lord, may I make one small submission, my lord? I will leave it entirely up to your lordship to decide the figure that is concerned, my lord, because I am now getting calls from the parties that I am not able to disburse the funds pending this application. Your lordship will kindly allow the application at whatever figure your lordship will please.
I also leave it to my lord. Whatever figure lordship decides.
Whatever figure your
Let's
lordship
not
decides,
bargain
kindly
with the
allow.
court. Whatever figure lordship decides.
My lord, part 1, part A has been completed. The other 3 parts are 5,000 each. 45 is the last. My lord, I will leave it entirely to your lordship to fix the figure. I will not intervene in this. But as Mr. Bose says, my lord, we also need to be reasonable for a professional.
Yes, we got. So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. Full stop. Special officer filed the present application being GA1 of 2025. Praying for a direction by allowing the special officer to use the service of the professionally qualified accountant firm so as to enable the special officer to ascertain with regard to the PAN, TAN, GST, TDS, and other taxes with regard to the rent and rent you're collecting. Rent.
My lord, the maintenance is being deposited in the nominated account.
To the maintenance amount, with regard to the maintenance amount collected from the tenants of the premises in question. The special officer has given the proposed charge of the professional accountant of the firm, namely AVB and Associates Chartered Accountant, wherein with regard to part 1, that is PAN, TAN and GST application, is rupees 15,000 plus GST, comma, नहीं, क्या बोला? No, wherein the chartered accountant has quoted the professional fees, which are as follows. इसको कर देना, ठीक है? As regard the part 1, there is no dispute for payment of the professional charges to the chartered accountant, but there is a dispute with regard to the professional charges as mentioned in part 2. Full stop. The chartered accountant has claimed rupees 20,000 per month, but the defendants have stated that the amount claimed by the chartered accountant for the part 2 work is much higher and it is to be reduced. Considering the submission made by the counsel for the respective parties and the proposed charge made by the proposed charge of the chartered accountant, this court find that it would be appropriate that the professional charges shall be rupees 15,000 per month. Shall be 15,000 per month. Full stop. Accordingly, the special officer is allowed to pay his professional charges to ABVP Associates for the work as mentioned in part 1 and part 2, as mentioned above. GA1 of
and to make the payment from the nominated bank account, your lordship will kindly clarify that.
The special officer shall make the said payment to the chartered accountant by transferring to the bank and keep the accounts and to maintain the accounts properly.
I'm very grateful.
Yes. What about the contempt?
Yes, well,
My lord, kindly takes it up next week, my lord, contempt. Kindly takes it up next week, my lord.
Next week?
Next week.
Well, he wants to avoid the inevitable.
No, my lord, that is not the, my lord, case here, my lord. I want to be better prepared to address, my lord, on this, my lord. I know I may have a difficult task, but I'll try to, my lord.
The prayer made by the counsel for the, as per the prayer made by the counsel for the alleged contempt, hearing of the contempt application in adjourned, let the matter appear on 30 January.
Yes.
Mr. Bose is.
I'm grateful. Obliged.
Great.
Huh?
Grateful, my lord. My lord, before your lordship takes up the matter, my lord, I would want to make one submission. Yes. But I would want to make one submission apart from the merits of the matter. My lord, one order has been pointed out by my colleagues appearing for the defendants that, my lord, I had appeared for an applicant in this suit previously, so I cannot appear possibly for the plaintiff. But I want to indicate whether there would be any conflict or not. I should indicate this. But I had appeared for an applicant who sought to be added as a party to the suit. That application was dismissed, and I did not appear for any other party to the suit ever. That was in 2018. Now, my lord, now I have been briefed to appear for the plaintiffs in the suit. But that applicant who wanted to be added as a party was not added as a party on my application. But now when I've been briefed, I find that that applicant and somebody else has already been added in the suit. And, my lord, we have, my lord, the plaintiffs have now taken out an application, my lord, for recalling or for review of that order by which this was.
They have been added.
for which these two
Have been added.
applicants have been added. So, my lord, I was, my lord, this is what.
So what do you want?
Originating someone's opinion of the court.
But I really do not know because
stand in the way.
That one question
initially,
one question be framed.
but that was in 2018 when my client was not added as a party, and I never appeared in the suit thereafter. But now I've been briefed
So you are appearing for the plaintiff.
for the plaintiffs.
And who has filed the review application?
The plaintiffs.
Then-
But yes, so plaintiffs have filed a review. But the review is sought of an order by which that applicant whose addition was rejected at one point of time and another applicant, these two had jointly filed an application.
Correct. Correct.
So for that review, the plaintiffs have filed.
So now how you can?
That is why I was saying that I should be pointing out this to your lordship.
You cannot, because what stand you will take now the plaintiff? But once you file an application on her behalf
No,
or his behalf,
not on the plaintiff's behalf.
the added,
Yes.
on behalf of the added, you filed one application for addition.
For addition of.
But that was somehow it was rejected.
Yes.
It was rejected. Subsequently, another application was filed along with other. And it was allowed by this
Yes.
court. Correct. Now the plaintiff has filed an application for review of that order wherein it was allowed. Addition of party was allowed.
Yes.
So what stand you will take if because you were one of the party at that time to add as a party?
But my advocate on record who was there, but is no longer there because
it is up
that
to
is
you. See?
But then, my lord, I'll today I cannot appear, my lord, possibly.
Okay. So what do you want?
But I should not submit my lord, my
My
advocate
lord,
on record.
be that as it may, in the meantime, my lord, the plaintiffs have preferred an appeal against your lordship's order for dismissal of the suit.
Allowed.
But modified to the extent that the review that they have filed that has to be heard out first. Till the time the review is heard out and allowed, the suit will remain.
You are not stated before the appellate court. They are not coming to the hearing of the review
we have
application.
stated, we have stated. So the appellate court was of the opinion that the review has to be heard out till the hearing of the review, and if it is allowed, then only the suit will be revived. Otherwise, the suit will lie dismissed. It will not be changed. So that is the order that has been passed, my lord. So they have not filed. Your lordship kindly, my lord, fixes a date for review. That is all I can pray. My lord, they have not filed their reply to the review application. We have filed our opposition, my lord, to the review.
Review to listing.
Review is not there. In the meantime, what has happened, my lord? Your lordship has been passing orders every month, my lord, for my lord releasing.
Just a moment, my lord. With regard to my lord, the division bench order, kindly, my lord, comes to paragraph 5. Your lordship's order, my lord, has not been set aside.
Correct. Remain.
So, my lord, it's order directing.
The directing dismissal should remain.
So that is only, my lord, for a very short period of time until, my lord, your lordship hears out the review. And, my lord, even the point of condemnation of
lordship's leave,
is open.
Yes.
Could I take your lordship's leave?
Even the point of condemnation of delay is open. So, my lord, nothing practically, my lord, has gone
With
against.
regard to the review application.
Review. Yes.
329 days.
So nothing practically has gone against, my lord, your lordship's order. Now, as my lord, Mr. Mondal was saying, my lord, we have been, my lord, coming up before your lordship when the suit was dismissed.
I was telling.
We have pointed out all this. Mr. Sen was there. Mr. Sen pointed out all this.
Yes.
But their lordships were of the opinion that the review should be heard out.
Yes.
Now, my lord, when the suit, my lord, was dismissed, we still had to approach your lordship, my lord, for some interim orders because the special officer who was appointed as the chairman is still continuing. Now, your lordship was pleased to pass orders, my lord, for release of certain amounts of money so that the company functions. My lord, similar is, my lord, one list which we can hand up to your lordship.
My lord, I've handed over.
If your lordship, my lord, can kindly permit. The only addition is number 10, where our advocates' fees are there.
So today review is not there.
No, review is not listed. Perhaps that is
what is fixed
required.
today?
My lord,
Only the GA.
What is the GA 28?
28 is our application wherein we have asked for, my lord, the removal of the special officer and for handing over of the charges of the company to the interim board. Wherein your lordship's interim orders have been passed, your lordship has kept the special officer till the time the handing over is complete and to, my lord, release the every month, my lord, recurring expenses. So this is the, my lord, chart that I've handed over to your lordship. That is the, my lord, expenses that we need to, my lord, meet out for the month of
January 2020.
I have passed an order. I think it continue.
Yes, yes.
Yes, yes. Your lordship has passed.
ठीक है। Just wait. Point
The
out.
minute special on release the remuneration of this clerk and bill telephone. Also raise the bills and to give the rent. There is no time fix.
It should be, my lord, I am appearing, my lord, also, my lord.
Yes, December 18 order, I have not specified. You can continue with this order.
I kindly clarify, my lord. Otherwise, every time we will have
That's
to
what I'm
come and
telling.
ask for
18
everyone.
December, that's why I not fix for the month. It is, he may release. In the meantime, special release the remuneration of the receiver and the receiver's clerk and to pay the property tax, employee salary, provident fund, CSC bill, office maintenance charges, and also to raise rent bills and to give the rent receipts.
Then, my lord, kindly clarify.
And this process, my lord, continued every month. Kindly say, my lord.
No, the practical difficulty which we are facing, my lord, is since your lordship has used, my lord, certain
Employees
heads.
uniform.
No, not just that. The important is number 10.
10 is your now today.
Yes.
And that is
very
attached to the
important.
employees uniform.
No, number 10, advocates bill.
Advocates bill for
That
Bengal.
is very important.
No, that is very important. While I tell you,
Now, that
lordship,
will be
because
decided before Puja vacation.
no,
So long. No, your lordship, it will come
no,
back to.
but I'll tell you, lordship, my lord, there is a suit which this company is to defend, and your lordship has appointed Mr. Thakkar as the advocate. So, my lord, if the special officer has to pay the learned counsel who has been engaged, otherwise, my lord, the interests of the company will suffer.
Because that's why the Mr. Sen is correctly because this court has appointed,
Yes.
but the
Yes.
company is not coming forward, giving
No,
instructions.
the special officer has said that since your lordship's order of 18 December speaks about certain specific heads,
Correct.
it's not an omnibus order.
Correct.
That's why he is only releasing employees' salary, employees' provident
Whatever
fund,
the
CSC.
necessity.
Yes. Now, whatever is necessary, if this word goes in, then
Yes, just your lordship will add one line that other necessary expenses in respect of the company shall be incurred by the special officer and released.
as he was doing always.
And only one prayer, my lord. Now that after the order of the division bench, it is that review application which is to be heard. So kindly give a short date and fix the review application. I am sure, my lord, that condonation of delay cannot succeed.
Because review was also
disposed of.
The review will not come. Because
Will not
has
go.
also been
It was
dismissed along with the suit.
review and consequently the suit.
Yes, the suit was dismissed. Any consequential applications will all be.
So appearing for the plaintiff. Who is for the plaintiff?
I'm appearing on behalf of the plaintiff.
You are appearing for the
Gupta
plaintiff.
was appearing because he cannot appear.
So appearing for the plaintiff. So appearing for the defendant number 2 and 4.
2 and 4 Mr. Sen and I am appearing
2 and 4.
2 and
I'm for defendant number 5.
So appearing for the defendant number 5.
And Lord, I am appearing for the staff.
Not the party, na?
Not parties.
Full stop. The learned counsel appearing for the plaintiff has handed over the order passed by the Honorable Appellate Court dated 20 January 2025, wherein the Appellate Court has directed that the order held that inward comma the order directing dismissal of the suit shall remain stayed till the disposal of the review application. Full stop, full stop. However, for any interlocutory purpose, the parties may approach the learned single judge. Full stop, not comma. As the suit was dismissed, consequently, the review application was also dismissed by this court. Now, in terms of the order passed by the Appellate Court, the review application is to be heard.
Along with the application for condonation of delay.
Is to be heard along with all connected application. In view of the above, the department is directed to place the review. What is the number? Place the review application.
PWO 19 of 2024.
Review application filed by plaintiff. Filed by the plaintiff being review number
19 of 2024.
19
and
of 2024.
GA1 of 2024, GA2 of 2024, which are connected.
Along with GA1 of 2024 and GA2 of 2024. In CS 159 of 2010.
In review.
GA1 and 2 in review.
GA1 review. Full stop. Let the review application and all connected application be placed before this court on
Any short date subject to law.
6th of February 2025.
Obliged, Lord.
Full stop. The
Good,
counsel for the parties submits that by an order dated 18th December 2024, this court has allowed the special officer to release the remuneration as mentioned in the said order and prayed for a direction upon the special officer to continue to release the said remuneration as mentioned in the said amounts as mentioned in the order dated 18th December 2024. In view of the submission made by the counsel for the parties, the special officer is directed to release the remuneration of the receiver and receiver's clerk and to pay the property tax, employee's salary, employee's provident fund, CSC, CESC bills, telephone bills, office maintenance charges and other, and also to raise rent bills and to give rent receipts and rent receipt of the rent from the tenants till the disposal of the present application.
Along with the advocates.
Yes, but the fees of the advocate, that has to be clear.
But they are not, I think, no, but they are not, I think that order has been recalled.
No.
Yes, Mr. Thakkar has come, they are not, then the...
No, that held before. Thereafter the interim board, when your lordship had formed the interim board has communicated with Mr. Thakkar, with Mr. Bagaria, and they are appearing. They are still appearing.
The special officer also directed to release the advocate bills who is appearing for the plaintiff company. Plaintiff company?
No. Not plaintiff.
No.
For the company.
Defendant number one.
Defendant number one. Who is the defendant number one?
No, defendant number one is the company.
Defendant number one, that is the defendant number one, that is
Company Limited.
Calcutta Safe Deposit Company Limited.
My lord, only one thing, my lord, GA 28, I have filed my affidavit in, my lord, reply. My lord,
Affidavit in reply filed in GA 28 of 2024, we've kept in the record.
My lord, only one thing, my lord, I am told that in the Section 5 application and in the review application, no reply has been filed by the petitioners there.
We would
so, my
like
lord, let it be understood.
It is made clear that in the meantime, if the parties fail to complete the pleading in
Yes.
the review application and the connected application, the review application and all connected application will be taken up for hearing without any.
Obliged, word. Very much obliged. Obliged.
My lord, item 16, I am for the plaintiff, my lord. My lord, it's a change brief, my lord. Yesterday I filed Vokalatnama and by mistake today I brought her.
Who is appearing? We are for the plaintiff?
Yes, my lord. It's a change brief. Yesterday I filed Vokalatnama and in hurry I brought the wrong brief, my lord. I'm praying adjournment, my lord.
Now, what is the stage of the suit?
My lord, as I am.
Yes, Mr.
My lord, may I tell your lordship? My lord, this is a defamation suit filed against my client, the defendant number one. The defendant number two is the brother of my client who's dead. My lord, defendant number one is also in the last stages of his life. He's suffering from cancer. Now, my lord, in this matter, the alleged defamation is this, that I have been writing to various authorities complaining against the bank officials.
Good.
That is, my lord, because the bank has been occupying my premises and has not been paying any rent. Now, my lord, my mouth can't be shut, my lord, from claiming my legitimate dues.
Correct.
That's, my lord, the point here. But, my lord, without going into that, I had requested my learned friend's predecessor, the earlier advocate, to see if the matter can be settled. Your lordship was of the view that we write a letter, my lord, to the advocates for the other side, requesting for an amicable settlement, because the bank
Who is appearing for the, you are for the bank?
Yeah, I'm for the
Let
bank.
the bank officer come here.
Kindly, my lord.
Settle it.
Kindly, my lord.
Defamation suit, what you will get the defamation?
Yeah, my lord, I just stepped out, stepped in, my lord.
The person is a bedridden person. What you one already passed away.
Because this type of information I don't have, my lord. That is
No, on the last
yes.
occasion. You take instruction, otherwise I call
Yes,
the,
my lord, fix a date. I will inform my client to be present.
and whether written statement, what is the GA2, GA4, what what are the GAs? So many GAs are there.
My lord, written statement, my lord, has not been filed.
I
And
have filed my written statement. I'm for the respondent number 3.
GA3, my lord, is, my lord, their application for interim orders filed 3 years after the suit was instituted. Where, my lord, they want an order restraining me from writing any emails to any higher authorities claiming anything. So, my lord, there,
So
your
now
lordship.
they have vacated the premises.
No, my lord. Now, what has happened? On one fine day, they surrender the premises by a letter. That letter reaches me 8 or 9 days later. Even before I get the letter, whereby they are intimating me that they've surrendered the premises, they, my lord, then wear the hat of a lender and take the premises physical possession under SARFAESI Act. Because there were two simultaneous accounts. One was my loan account, whereby I was to repay money, and the other loan, other account was.
What is the amount due against you?
My lord, in 2019 there was a settlement entered into, my lord, with the bank. In that settlement, it is an internal document of the bank where the senior official of the bank has informed the branch that you settle with this person, and after adjusting both sides, my dues and the dues payable to me, 28 lakhs was agreed that I would have to be given 28 lakhs, and me receiving 28 lakhs, they would give me possession of my property, and all my claims would also stand, my lord, settled. When I went, my lord, to Bombay, I was called to Bombay to meet a senior official in the bank. When I went there to have this implemented, my lord, I was asked for a bribe. I refused to give that bribe. When, my lord, I didn't give the bribe, this offer, my lord, was withdrawn. That is when, my lord, I filed, my lord, I made some communication alleging that there is bribery and that I am being accused of non-payment, but actually I am to receive money. And because of me not giving a bribe, this matter is not coming to an end. This is the cause of action for the defamation suit. And during pendency of the defamation suit, matters pending before the DRT, DRT has passed an interim order in my favor, staying, my lord, the bank from taking any further steps under SARFAESI Act. So they haven't been able to sell my property. But the matter of fact is that that's my only asset, and the bank is still sitting on it. And because of the sluggish pace at which the DRT runs, my lord, the matter is just pending, my lord, sub judice, and there's a stay. This is where, but my lord, in the meantime, now I have, my lord, now I'm nearing the end of my life. My lord, if in the next 2 or 3 months, if this matter can be settled, at least one of these generations, 2 daughters of the person, wife, my lord, women of the household, my lord, no one will be able to pursue this. And, my lord, lakhs and lakhs of rupees pending, property stuck, which is why, my lord, I'm not even wanting to go into
What is the claim of the bank now?
My lord,
Leave aside this, what is the claim of the bank in the SARFAESI?
in SARFAESI, my lord, exact figure, my lord, but it is about somewhere between 1 crore and 2 crores. And but my lord, my claim is much higher. And if I take into account my losses and everything, then it's almost 30 crores. But I'm willing to forego all of that. Just pure principal claim, my lord, if it's adjusted, 28 lakhs I am to get.
So appearing for the plaintiff, so appearing for the defendant. Counsel for the plaintiff submit that this is a change brief, and just now he has been engaged by the plaintiff bank and prays for time. In view of the submission made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 12th of February. Next.
My lord, would your lordship?
My lord, on that day, my lord, your lordship is directing me to a bank official should be present.
No, you take instruction. What can be done? He was.
Yes, my lord.
You knows in the.
I got information, my lord. There are several litigation pending
Maybe
before several.
that's why I'm
courts.
telling. That's
Yes.
why I'm telling. See, with regard to the defamation suit, you knows.
Yes.
What will be the last?
Actually, now so far I understand, my lord. Now it is ego class, something like that.
Correct.
Yes. So the bank official is the appropriate person.
Lord, could one line go into the order that they'll take instructions on how to resolve this amicably, my lord?
That will be
It is
great.
no
Because
Yes.
because
Next, call the matter.
my lord, kindly extend my time to put in my affidavit.
What?
GA3, my lord.
Filed.
Not filed, my lord.
Counsel for the
Person is
defendant
ill,
pays
my
for-
lord.
Counsel for the defendant pays for time to file. Pays for extension of time to file affidavit in opposition connection with GA3.
let affidavit in opposition file within
3 weeks, my lord.
then how it can be on 12th? Affidavit in opposition filed with 2 weeks, reply if any there to be filed within a week thereafter, then let the matter come on 20 February, not 12, huh?
25th February.
20.
20th February.
20th.
Much obliged.
Grateful.
Yes.
Order 7 Rule 11 application filed by my learned friend. We have completed. I have also completed. Only a certain part is left on my part, my lord. I will just complete it, my lord. Suit for eviction and recovery of possession. My case in the plaint that the original tenant has expired. 5 years has passed. The son of the original tenant has also expired. Now the daughter-in-law is in wrongful possession of the suit property. The plaintiff is seeking recovery of possession by evicting the defendant therefrom. Now they have filed a Order 7 Rule 11 application. Now whatever they have stated in the Order 7 Rule 11 application are all on merits, facts. Now it's well settled that in Order 7 Rule 11, my lord the courts will only look into the plaint, the four corners of the plaint, nothing more, nothing less. Now I have a judgment to that effect, my lord. I will just hand over that judgment. It's a 2023 judgment. Yeah, I mean, I'll give you. The 2023 SSC online SC 1612. Lordship will kindly come to 17 para 17.
You are for the plaintiff.
I am for the plaintiff. It says para 17, and then your lordship will kindly turn the next page. Order 7 Rule 11D of the code has limited application. It must be shown that the suit is
What
barred.
point? What point is the judgment you are citing?
The merits or evidence cannot be looked into at the time of deciding an Order 7 Rule 11 application. So on that point. Because your lordship will kindly look into their Order 7 Rule 11. All whatever they have stated is on facts. They claim in their Order 7 Rule 11 that they are the tenants of the suit property. My case in the plaint that they are in wrongful occupation of the suit property. That's the kind of best defense they can take in their my Chapter 13 application, which is pending, not in the Order 7 Rule 11 application. Para 17, and thereafter the quoted paragraphs 21 and 22. A Supreme Court judgment has been quoted in the 2023 judgment. Order 7 Rule 11 has a limited jurisdiction and must be shown that's barred by any law. And para 22, for the purpose of invoking Order 7 Rule 11D of the code, no amount of evidence can be looked into. The issues on merit of the matter which may arise between the parties would not be within the realm of the court at that stage. All issues shall not be the subject matter of an order under the said provisions. Now, ultimately, the last paragraph, the concluding paragraph, the last page of that judgment, page 12 of that judgment, as noticed above, no amount of evidence or merits of the controversy can be examined at the stage of the decision of the application under Order 7 Rule 11 CPC. Hence, in our view, the impugned order of the High Court passed in the review application deserves to be set aside. Only that point, that no amount of evidence or matter in controversy cannot be looked into. That will be looked into in the defense, my lord.
Which paragraph you read?
The last paragraph.
27.
26, the end part, as indicated, noticed above. Lordship got it? Page 12.
Where is the 11th page?
There, my lord.
That is I'm telling.
It's 11 is there.
Page number 11 is missing, sir.
Missing. So can you give your copy? I will just maybe in the printout it has. It's here. I'll give you another. Zero. $26. That's the paragraph I am
Cannot be
referring.
considered. Yes, that is missing here.
Maybe in the printout.
So that's all.
That's all. I will see the order 7, rule 11.
Yes, sir.
They've completed.
Not if your lordship kindly takes up the application itself, not
GA9.
Yes.
GA number.
4 to hai gaise. 9 to.
What is the GA?
GA 9. 9.
GA number
9.
GA9.
Rejection of print GA9.
GA9.
Yes.
GA9.
That is another question. Commercial.
Well, that is well settled by my lord, in the various judgments. That's a dispute which arises out of an agreement. There should be a written agreement. Here, there's no agreement between the plaintiff or the defendant. That's my lord has settled.
But in GA9, not the plaint is annexed, not. If your lordship kindly looks at the plaint itself,
that my lord settled in one of my matters only, that there should be an agreement.
here they have categorically admitted that it is a non-commercial premises, not let out for the purpose of go down. It is not a residential premises. And if it is not a residential premises, not, then we are relying on the provisions of the Section 2G, Lord. If
Is
it
the
is not
Commercial Code Act?
Commercial Code Act, no?
Yes. Which provision? Which
Lord,
clause you are relying on? 2C?
Lord, may I place it, Lord?
Yes. Which provision you are relying upon?
In respect of the premises let out for non-residential premises for spouse, son, daughter,
Where? Commercial?
Commercial Code.
Commercial Act?
No, my lord. Premises Tenancy Act.
Section?
2G. Tenant. Definition, Lord. Tenant means any person by whom or on whose account or behalf the rent or any premises is or but for a special contract would be payable, and includes any person continuing in possession after the termination of his tenancy.
That's correct, sir. That is not disputed. You are not. But
no, Lord. Thereafter, Lord, I'm
you
coming.
show me the Commercial Code Act in which provision of 2C, which clause you are coming under.
Yes, Lord. He itself, it is here.
I am telling you to show me the Commercial Act, which clause you are coming under.
It is here in itself here in this definition itself, Lord.
Commercial Code definition is provided
Not
in
commercial
the
court, Lord. It is a non-residential premises.
I am asking which clause the case of the plaintiff is coming under the Commercial Code Act. Show me that.
It is not Commercial Courts Act, Lord.
If they're not Commercial Code, how the Commercial Code, the suit will come in the Commercial Code?
I'm not asking for Commercial Code.
Kindly come to your case.
It is not. It has been let out for non-commercial.
Kindly come to the paragraph 18.
Yes, not. Admittedly, the suit property is the commercial property wherein the suit room is being carried on under the name and style of the Jashoda Stores, which is situated on the ground floor of the premises number 13B Bidhan Saroni, within the police station Shampukur, Probir Kundu died intestate on 2/2/2018, leaving behind his widow Runa Kundu and one son, who is aged about 8 years, and one minor daughter who is aged about 19 years. The fact that the suit property is a commercial property is undisputed, and hence the suit framed is not maintainable, and the plaintiff is liable to be rejected.
That's why I'm asking. Show me under the Commercial Court Act which clause it is
But
coming.
here, Commercial Courts Act has nothing to do with it.
So admitted it will not go to the Commercial Court.
No.
So admitted.
Yes, my lord.
Okay.
It has nothing to do with Commercial Courts Act.
Because the paragraph 18 which you have framed, that is of the Commercial Court. What you are telling? Why it is not maintainable?
It is not maintainable because, my lord, they are saying that 5 years embargo has elapsed, my lord, and hence we have become a trespasser in respect of the property.
Yes.
They have not given any notice, and we are a trespasser in the property, and hence we are liable to be evicted. This is their case, my lord.
Correct.
And for that reason, they have filed the suit that we are a trespasser in the property.
Correct. Correct.
And it is they say that this is a residential premises, and since we are
So that's why, if it is so, you are telling that as per the provisions of 2G of the Tenancies
It's
Premises
a non-commercial property, my lord.
Tenancies Premises Act. Correct.
It is a non-residential property.
Correct. You are telling it is non-residential
Yes, my lord.
property. He is telling that it is residential. It has been given a residential.
No, I have not.
He is telling, just he has stated.
Yes.
You stated, just you stated.
We have stated that it is a non-residential premise.
Correct.
Yes.
Non-residential. For what purpose it has been issued?
For go down and a shop.
Where is that?
In the plaint itself. Not?
Show me the paragraph. Persons are making some case in the plaint and some making some submission before the court. Which paragraph?
Can you see the schedule? Page 52, running page 52, inner page 8 of the plaint, my lord.
52?
Yes, my lord.
Yes.
All that one go down, along with a side space measuring an area of about 264 square feet.
Yes.
Situated on the ground floor of the municipal premises number 103B, Vidhan Saroni, PS Shampukur, Kolkata 70004, which is butted and bounded by such and such.
Okay.
Then, Lord, Schedule B, two premises are there, Lord.
Okay.
All that one wooden structure go down with tin shed measuring such and such, Lord.
Okay.
About 348 square feet, situated on the ground floor of municipal premises number.
Yes.
So it is not a residential premises. Admittedly, it becomes a non-residential premises.
Correct.
Lord.
Correct. Okay.
So here we come to the definition. If your lordship now comes to the definition.
Yes.
Lord. The tenant means any person by whom or on whose account or on behalf of the rent of any premises is or but for a special contract would be payable includes any person continuing in possession after termination of his tenancy, and in the event of death of any tenant also includes for a period not exceeding 5 years. This they are applying, Lord. From the date of death, such tenant from the date of coming into force of the act, whichever is latter, his spouse, son, daughter, parent, and the widow of his predeceased son, who were ordinarily living with the tenant up to the date of death of the tenant as the member of his family and were dependent on him, and who do not own or occupy any residential premises, and then Malat come. In respect of premises let out for non-residential premises purpose, his spouse, son, daughter, and parent who were ordinarily living with the tenant up to the date of death of as member of the family and were dependent on him, or a person authorized by the tenant who is in possession of such premises, but shall not include any person against whom any decree or order of eviction has been made by a court of competent jurisdiction.
Yes.
So, my lord, this has been excluded, my lord. And here, my lord, I will be relying on two judgments also, my lord.
Yes.
This is reply, my lord.
No problem.
Reply stage.
Your lordship kindly looks at this, my lord. One is Dipali Haldar.
What judgment it is? Where from you got the judgment?
But it has been downloaded, my lord, of
From
this
where?
honorable court, my lord.
From
Calcutta
where?
High Court, my lord.
It is not the Calcutta High Court website, sir. Indian Kanun I will not accept.
Then, my lord, another is Nasima Naki, my lord. Tenant who is the first proviso clearly does not apply to premises let out for non-residential purpose.
Where
It is
from?
only the second proviso that applies.
Which paragraph you are reading?
Not,
Which paragraph you are
now,
relying
Lord,
upon?
comes to
Which paragraph?
paragraph 19, Lord.
Paragraph 19?
Yes, Lord.
Okay. Yes.
It may be observed that this may be a colossal case of casus omissus. In this context of premises let out for residential purpose, both the proviso of 2G of the Act apply. Since the first proviso exclusively deals with continuing rights of the spouse of an original tenant in respects of premises let out for residential purpose, subject to the conditions stipulated therein, the lesser right conferred by the second proviso to the other heirs of an original tenant would be inapplicable in the case of a spouse. However, in the last sentence of the proviso of section 2G of the Act, clearly specifying that it would be such proviso that would apply mutatis mutandis to proviso let out for non-residential purpose, the operation of the first proviso is barred in respect of the premises let out for non-residential purpose.
Okay. That's all?
Yes, Lord. This is the interpretation of that provision, Lord.
Okay. Anything further?
So, Lord, in that respect, Lord, the suit that has been framed on the face of the plaintiff itself, Lord, without going into any further record, and what they have stated, and the bills that has been annexed, and the admitted documents, Lord, that it is a non-residential premises, Lord. It is a go down. They admitted that. So this 5 years embargo cannot apply, Lord, here, Lord. And this plaintiff is liable to be rejected, Lord, on that.
Okay.
Court. And that is the reason this Order 7 Rule 11 application has been filed.
Yes.
Now, just, my lord, I will take 5 minutes. Now, my learned friend has argued with the merits of the matter, my lord. If my chapter 13 is today before the court, my lord can simultaneously hear.
With regard
Now,
to the how
yes,
you maintain the suit.
Yes, absolutely. My lord, will kindly come to para 5 of the judgment relied upon by my friend. 2019, volume 2. The issue which fell for consideration of the division bench is para 5A, 1, Roman 1, where the spouse of a deceased original tenant is entitled to a life protection from eviction in respect of the premises let out for non-residential purpose. This was the issue, and the answer to that has been given in para 23 of that judgment. The two legal principles questions are thus answered as follows. The first answer, the spouse of a deceased tenant is not entitled to a protection from eviction in respect of premises let out for non-residential purpose. Here the premises has been let out for non-residential purpose beyond the period of 5 years from the death of the original tenant. Here the tenant died in 2015. So her protection at the best could be till 2020. Suit is of 2021. If such original tenant died after coming into force of the 1997. This is the first. Second, since my learned friend has relied upon that judgment, he should have, this judgment went to the Supreme Court also. I will show your lordship the judgment of the Supreme Court also. It has been affirmed before the Supreme Court. I have the judgment of the Supreme Court. It's a 2019 SCC online SC 1601. I will give my learned friend with that copy of that judgment. Your lordship will kindly come to para 11, the last 2 lines of that paragraph, where the premises, I think my lord's copy is marked.
Paragraph 11?
Para 11 of that judgment. It's marked with a, where the premises have been let out for.
Paragraph 11?
Para 11 of that judgment. The judgment which I handed over just now.
Which one? The Supreme Court?
Supreme Court, 2019 SCC online SC 1601.
Yes.
Para 11, your lordship got it? The second 2 lines. Where the premises have been let out for non-residential purposes, the protection also extends to the spouse, son, daughter, and parent who were ordinarily living with the tenant up to the death as members of the family and dependent on the tenant or person authorized by the tenant who is in possession of the premises. So 5 years protection, as in residential, also extends to non-residential. That's para 11. In other words, I will repeat. In other words, in relation to residential parents, the protection of a tenant is extended for a period not exceeding 5 years. From the date of death of the spouse, son, daughter, parent, widow, and to the predecessor son, subject to the fulfillment of where the premises have been let out for non-residential. Protection also extends to the spouse, son, daughter, and parent, and if these 2 conditions are fulfilled. So protection for 5 years. 2015, the original tenant has expired. 2020, at best, the statutes gives the protection. After 2020, no protection. That's my.
Okay. Yes. That's all. Sense suffering for the plaintiff, sense suffering for the defendant. Hearing concluded. Hearing. In connection with GA9, na?
Yes, yes, sir. So, if my lord is with me, my lord, I have a chapter 13 application.
Let me see.
My lord, prior to my lord takes up the testamentary matters, the next 2 matters, 18 and 19, it's my application for judgment upon admission. The injunction which was granted is due to expire today. If your lordship would be pleased enough to extend the time suitably. The other side is Miss Manju Agarwal who was appearing.
It will
I
be
believe because of.
Come at 2, it will be called.
No, my lord, because there is a bereavement in her family. She might not appear. That is what I'm saying, submitting. Mrs. Manju Agarwal who is appearing on the
no
other
problem.
side.
You mentioned at 2 p.m. I will take that. I will take
Very.
My October 2021, my land friend has approached my client not for a settlement.
But is that matter, my lord, whether RERA was coming into
applicable or not? Now, my lord, my client will sit. So, my lord, I expect a settlement to come forward. And
only praying, my lord, a fortnight's adjournment if it comes.
Come at 2, I pass out.
My lord, great. In the event I am not there, my lord.
Okay, anybody. Yes.
My lord, I appear for the caveator, my lord.
Kind of approach and try. This is that matter where I suggested that it could be settled because it's only one daughter who has
objected for that.
Not given the consent. The 3 daughters have given. The mother who's expired, she has given. So there is no reason particularly to believe that the ingenuity of the will or whatever the son is now propounding. Now, unfortunately, the elder sister, I'm told by my client that the elder sister also spoke or something, but they did not come through because I spoke myself personally to the advocate record day for yesterday. So she asked for a copy of the will, thereafter never came to collect it. So
yes,
my lord, if to my instruction, my lord, there had been a call made to the advocate on record, my lord, only to hand over a copy of the will and petition, my lord. My lord, so, my lord, as I am told, my lord, there had been an instruction, my lord, or rather communication from my senior friend, my lord, with regard to the settlement talk, my lord. However, my lord, nothing has happened with the client, my lord, with the Caveatrix and her sisters, my lord, is my instruction, my lord, with regard to the settlement. My lord, my Caveatrix, my lord, is still willing to settle the matter, my lord, if my lord is pleased to grant this, my lord. However, my lord,
Where is the Caveatrix?
lord, she's in Kolkata itself, my lord.
And where the petitioners?
In Kolkata. The
My lord,
proposal letter is there with me. WhatsApp was made. The elder sister, I'm told. And in fact, I
my lord,
think
if
I
there is any
understand that
proposal, my lord.
the Caveatrix's husband is also there in court present. So she may always say that what is the
My lord, if my lord, there is a letter proposing settlement, my lord, we shall be happy
What
to.
settlers? Sit together. What is their sisters?
My lord, if my lord, if
Then
one
you will send this. Then you will interpret, and he will interpret. Sit together, both the sister. Yes, yes, no, no. That's all.
That
my
is
lord,
the reason I myself personally called up the advocate on record, lordship. Sometimes
my
I
lord,
have
in the
intervened
meantime,
Marshal, I call all the parties here.
my lord, that would be ideal if the matter could be settled outside of court, my
next
lord.
week, any day,
My lord, if my lord keeps this, my lord, again with
How
humility,
much
my
time
lord,
you want?
my lord grants me,
Both are residing in Kolkata. Then
my lord, if
I've got no objection, lord.
my lord, if in the meantime I may be granted a copy of the will at least, my lord.
That day also I offered.
so and suffering for the plaintiff petitioner, so and suffering for the Caveatrix. Full stop. As per the submission made by the counsel for the parties, the case is adjourned. Let the matter appear on 19th of February.
Grateful, my lord.
How much? The previous week, lordship, 10th.
13th.
Inconvenient.
13th February.
13th. Obliged, lordship.
My lord, if they
time chahiye.
no, time China. My lord, shall we be granted a copy of the petition as well, my lord? Of
Take
the
the will
probate
copy.
petition?
See, petition, what he will say. Will is the only challenge.
Yes,
Take
sir.
the will, sit together.
that
If
is
you are having difference on the will, come and sit. Yes, this is not. Then we'll sit to that.
My lord, if
You know the what the contents of the application.
my lord, if in one indulgence, my lord, I
If
may
you're
be
telling
granted,
that in the application there is allegation against you, if you settle, I will expand that in my order.
my lord, one indulgence, my lord, is that my lord, since I have been granted a copy of the will today, my lord, if I may be, if the timeline for the opposition, my lord,
Come on
affidavit in
that day.
support
Come
of Caveat may
come
be
on 13th. Come on 13th. If it is not settled, come with your affidavit, whatever it is, then I will
grateful,
see
my
to
lord.
that.
Grateful, my lord.
Deeply obliged.
My lord, item number 51, I appear for the petitioner, my lord. The probate of a will of Shakuntala Devi Todi. All the legal heirs have given the consent. On the last occasion, your lordship, in terms of section 283(3), directed the petitioner to cause publication, my lord, because one of the properties is situated in Mumbai.
ये कौन type किया?
My lord, yes, my lord, there is a typographical error, my lord.
Dedicated. Petitioner dedicated. Direct.
Second last paragraph, my lord, directed. My lord, the only difficulty is like as far as the English newspaper is concerned, the publication has been done. But to be very candid, my lord, the Hindi newspaper publication has not been done. I have prepared an affidavit annexing the English publication.
But what about the Hindi?
My lord, in that case, my lord, my solicitor instructed if it is instead of Hindi, can it be, my lord, directed to be in the Marathi paper, because they are, this is Shakuntala Devi Todi, Navy Mumbai. My lord,
once has passed an order for Hindi newspaper.
my lord, I'm seeking then 1 week's time, my
the
lord.
petitioner. Police counsel for the petitioner submit that. As per the direction, as per the order dated 6th of December 2024, the petitioner has published the notice in the English daily newspaper, namely
Times of India.
Times of India, but the petitioner could not publish the notice in the English newspaper at Mumbai. And as such, he pressed for extension of time for publishing of the notice in the English daily newspaper. In view of the submission made by the counsel for the petitioner, time to publish the notice in the Hindi newspaper is extended for a further period of 2 weeks. List the matter on.
May I submit this affidavit?
List the matter on 19th of February 2025. The affidavit of service disclosing the original publication of the notice in the Times of India be kept with the record.
Grateful, my lord. Grateful, my lord.
In this matter, I am appearing on behalf of the co-founder.
Yes, the last occasion, Lord, the Lordship had fixed this matter as Lord final revocation application filed, Lord. Till date, Lord, nobody is interested.
None appears on behalf of the applicant.
My lord.
Praying for the applicant has filed. Today also nobody is there. GA2.
My lord.
What are the ground?
Lord, they have indicated the principal ground. What I find, Lord, is
no notice.
The name of Lord the beneficiary is same with the name of Lord the applicant. Lord, they are daughter-in-law and Lord mother-in-law. So Lord taking advantage of that name as if Lord the beneficiary has made signature while receiving the citation. Lord, completely Lord made up stories, Lord. Even the signatures do not match.
So appearing for the propounder. The applicant has filed an application being GA2 of 2024, praying for revocation of the probate granted by this court dated.
Lord, probate granted on 16th of March 2023.
Dated 16th of March 2023. Full stop. It is fine from the record. The matter was listed on 8th of January 2025, but none appears on behalf of the applicant to move the application being GA2 of 2024, wherein the applicant has prayed for revocation of the probate granted by this court. But for the interest of justice, the case was adjourned till today. In the order dated 8th of January 2025, this court has categorically stated that if on the next date fixed, if the applicant failed to appear before this court, necessary order will be passed. Today also, when the matter is called, none appears on behalf of the applicant. None has moved the application being GA2 of 2024. Accordingly, GA2 of 2024 is dismissed for default.
For the
My lord,
petitioner, my lord.
Caveator number 2 and 3, my lord.
Your
My
lordship,
lord, on the
recollect.
last occasion, my lordship was pleased to allow me to take steps, appropriate steps with regard to showing my caveatable interest, my lord. My lord, I filed this affidavit with a affidavit of service, which has been duly served upon them, my lord.
Your lordship, on the last occasion, we had filed an application for discharge of the caveats, my lord. Your lordship, there were two heirs of the deceased, my lord, wife and son. Wife has passed away, your lordship, and the son had filed a caveat. No affidavit was filed in support of the caveat. Your lordship, there was an advertisement and a publication was also made, my lord. Thereafter, your lordship, when we had sought for a report, no caveat was there. We had filed an application and your lordship had marked this for uncontentious cause. Now, my lord, these caveators, number 2 and 3, they have come up with they have filed a caveat and an affidavit in support of caveat, and now they have filed an affidavit claiming to be the purchaser of the estate, your lordship, of the deceased.
From whom you have purchased?
My lord, I have purchased from the legal head, that is the son. The son, my lord.
Before the death of the testator?
After the death, my lord. After the death.
Your lordship, now, your lordship, the caveatable interest they have to establish, my lord. Today, they have only filed an affidavit, my lord. Technically, there is no recalling application for the matter to already be marked as uncontentious, your lordship. Now, Your Lordship, the caveatable interest, if it enlarged to the extent that a stranger, today, Your Lordship contemplates that if this is marked as a contentious cause and a testamentary suit is filed, Your Lordship, then they as a defendant cannot challenge the will, my lord.
Correct.
There is no caveatable interest in the matter, my lord. Your Lordship then will have to go into the right title and interest of the property, which is not permissible in the testamentary jurisdiction, Your Lordship. So what I'm seeking today that this caveats be discharged, my lord, and this not be
They have
entertained.
filed the caveat.
My lord, I
filed
filed
a
my
caveat?
caveat and
Where is
I
the
filed
caveat?
my
Where is the caveat?
On the last occasion, Your Lordship, a
my
report
lord,
was filed.
report was filed.
Caveat hai kya? Dekho inka.
My lord, the affidavit in support was filed within time, my lord.
Correct, but see, this is the grant of probate of the will.
My lord.
This is the probate case.
My lord.
The probate court has to ascertain with regard to the genuineness of the will.
My lord.
Nothing else. The court cannot decide the title. If my father has given the will to me with regard to the High Court has been given to me, the court has to see whether the probate has been, my father has signed the will in his fit state of mind in presence of the witnesses. It cannot be said that whether High Court will be given to me or not. With regard to you are claiming the title, there is other appropriate forum. Whether you can take the appropriate relief, pray for appropriate relief in terms of your title. The court cannot decide. I will decide this, you take appropriate steps. Probate will not, you can go for the appropriate court for your right title interest in terms of the in terms of the deed. How this probate court can decide with regard to the deed is valid or not, or whether you have got the right title. Right title interest court, this court cannot decide, madam.
My lord, the principles in this regard is clearly set.
That is the main principle.
My lord, may I be
regarding the grant of probate is only the administration of the property in question.
Yes, Your
Nothing
Lordship.
else. The court is not declaring the title upon the tested the executor or executory, whatever it is. The court only giving the administration of the property with regard to the will.
My lord.
My lord, I leave it upon my lord.
In this regard, Your Lordship,
lord, I
since
leave
she
it
has
upon
filed a, there are
considering-
two caveats on
considering-
record, Your Lordship. I have to technically file an application before my lord for discharge of the same, my lord. Some time be given. In the meantime, we'll come up with the application. So these caveats are also discharged,
Have you
my lord.
received the affidavit?
Your Lordship,
My lord,
I've
it has
received
been
the
duly served
affidavit
and
in
an
support of
affidavit of
caveat
service has
as well as
already
the
been filed.
affidavit that has been filed today. I've received that.
So and so appearing for the petitioner. So and so appearing for the caveator number 2 and 3. The counsel for the caveator and the caveator number both are filed. This
My lord,
affidavit?
caveator number 2 has been authorized by caveator number 3.
Both are filed.
Both are
The
filed. my lord.
caveators have filed an affidavit disclosing the deed of conveyance and claiming that the property has been purchased by the caveator. Purchased by the caveator. Full stop. The affidavit has also served to the learned counsel appearing for the petitioner. Learned counsel for the petitioner prays for time for taking appropriate steps. In view of the submission made by the counsel for the petitioner, the case is adjourned. Let the matter appear on
A fortnight's time, Your Lordship, will
on
suffice.
20 February.
20th February.
My lord, one small indulgence. My name has been misspelled in all the orders, I believe, my lord.
What is your name?
My name is Farnaz Naseem. It is mentioned as Faraz Naseem. my lord.
F-A-R-N-A-Z.
N is missing. N is missing.
The counsel for the caveators submits that her name has been wrongly spelled in order dated
Almost all the orders, my lord.
only order dated 18th of December 2024, as her correct name is 18 December, 21st November, 20 September. Her correct name is F-A-R-N-A-Z, Naseem,
My lord.
N-A-S-I-M, Naseem,
My lord.
instead of Faraz Naseem. That in all the orders, the name of the caveator is learned advocate appearing for the caveator shall be read as Farnaz Naseem instead of Faraz Naseem.
Grateful, Your Lordship.
My lord, much obliged.
My lord, I am for the petitioner, my lord.
Yes.
This is pertaining to a grant of letter of administration of a will, my lord. This is a final hearing. My lord, to start with, my lord, the testator executed a will in 2010 and the testator died in 2018.
2010. Have you had his evidence?
Yes, my lord, I have.
Why?
My lord, two of the attesting witness was not available, my lord.
Okay. So this is the will.
This is the will.
Will dated?
Will dated, my lord. Will
16th March.
16th March 2010.
Correct. Then
which was registered, my lord. Thereafter, my lord,
registered will.
2021.
No, in the will there is no executor. That's why letters of administration.
Yes, my lord.
No executor's name is there.
Yeah. No executor. Executor was there, my lord. The executor died in 2021.
Where is the name of the executor?
Page 3. Page 3, Sunil Ranjan Dasgupta.
I appointed my brother-in-law, Sunil Ranjan Dasgupta.
And I have annexed the death certificate of the executor.
When the executor died?
4th February 2021.
Where is the death certificate?
My lord, it is annexed, my lord, Annexure C. Annexure C. That page.
4th February 2021.
Sunil Ranjan, Annexure C.
No. This is executor.
Yes, my lord.
What about the testator?
Testator, my lord, this certificate is annexed, my lord.
Where is that?
Annexure A. Sunil Dasgupta.
Dilip Sengupta.
Yes, my lord.
Testator is Dilip Sengupta.
Yes, my lord.
2018.
Yes, my lord.
And the executor died on
2021. The date is, my lord, the date is 4th February 2021.
After 3 years, yes. Then,
my lord, the testator died, leaving behind 3 legal heirs, the wife and 2 daughters. 2 daughters has accorded consent in favor of.
So who has filed the application for
the wife?
Wife has filed. And 2 daughters are given consent.
Yes, my lord.
Where is the consent?
Consent is there in the record.
Mithu Roy
and Nina
Sengupta. Yes. Then
the petitioner has paid the maximum court fees because the
attending witness.
Yes, my lord.
What is the name? Sanjay
Attending
Sengupta.
witness Sanjay, Mr. Sanjay.
Where is the evidence of the Sanjay Sengupta?
Yes, my lord.
ये folio कहाँ है?
Sanjay Sengupta. He's the grandson of the deceased. The affidavit is also there. The affidavit is also there, my lord. He has identified the signature of the testator and that of the attesting witness. The signature of the testator has been marked as exhibit. We come to the affidavit.
Yes. So appearing for the petitioner. The petitioner has filed the present application for grant of letters of administration of the last will and testament dated 16th March 2010 of the testator Dilip Sen Gupta. Counsel for the petition submit that the testator has executed his last will by appointing his brother-in-law, namely Sri Sunil Ranjan Das Gupta, as sole executor of his will, of his last will. But unfortunately, the executor also died on 4th of February 2021 before applying for grant of probate. And as such, the petitioner, being the wife of the testator, has filed the present application for grant of letters of administration. Counsel for the petitioner submit that the testator died on 9th of March 2018, left behind his wife and 2 daughters. The wife is the petitioner before this court, and 2 daughters have filed their affidavit of consent. Counsel for the petitioner submit that the testator has executed his last will and testament in presence of 2 attesting witnesses, but unfortunately, the whereabout of the 2 attesting witnesses could not be ascertained. And
In this regard, my lord, a paper publication was also
could not be ascertained. And the petitioner has made paper publication for the notice of for the purpose of appearance of the attesting witness before this court. क्या बोला?
Where about all the 2 attesting
Asset.
the petitioner has made paper application for the purpose of appearance of the attesting
Before this court. But in spite of publication made by the petitioner, none of the attesting witness has come forward. And thus, to prove the will, the petitioner has examined 1 attesting witness, namely Sanjoy Sen Gupta, who is the grandson of the testator. Counsel for the petitioner submit that as per the evidence of the attending witness, he has categorically mentioned in his evidence that the testator has executed his last will and testament in his presence and has signed the said and executed the executed her last will and testament in his presence, and the said attending witness also identified the signature of the testator, and the signature of the testator in the said will is marked as Exhibit A. Counsel for the petitioner submitted that the petitioner has proved the will and is entitled to get the letters of administration. The learned counsel for the petitioner peruse the original will, death certificate of the testator, death certificate of the executor, consent affidavit of consent of the daughters of the testator, and the evidence of the attending witness. Considering the above, this could find that the petitioner has proved the will and is entitled to get probate and get letters of administration of the last will and testament dated 16 March 2020. As per the full stop. The department 2020 2010. What is the assets?
the assets that I have paid for furnishing of.
What is the cost of this total value of the property? Where is the affidavit of assets?
Yes, my affidavit is there.
30 lakhs only?
Yes, ma'am.
30 lakhs? The department is directed to issue. And is entitled to get. The department is directed to issue probate, issue letters of administration to the petitioner upon furnishing bond of rupees 3 lakhs with one surety upon 3 lakhs with one surety upon compliance of our formalities. At the time of grant of letters of admission, the copy of the will be made part of the letters of admission. Yes, next.
And I'm the petitioner, my lord. And on the last occasion, there was a last chance in regard to this. Last two occasions, there were chances given for discovery inspection. They wanted some time to get inspection in respect of a property, in respect of some assets which are the last chance was given on the last occasion. Now also that has not been done, I'm told.
But I'm not saying anything, but I'm only saying that we have been granted inspection of the premises which was under control of the bank. My lord, we have inspected all the documents. As of now, we have no documents to disclose. Now, my lord, first, my lord, I would believe it is the plaintiff's duty to serve me with a notice for inspection of their documents. Whatever they want to disclose, that has not been done as per my instruction.
Because this
But I
was-
do not know. My lord, the plaintiff has to do it first. But then
Have you inspected the document?
But I've inspected my documents, but there's no
in the bank.
in the
We have
bank.
already
Yes,
given the
we have
inspection.
done.
Okay, so you have disclosed the document
My
for
lord, my lord.
inspection.
They have inspected.
They have inspected all the documents, my lord.
In my I've just taken instruction 5 minutes back. I was told that no inspection has been given of their documents.
Where is the communication? Inspection communication. Where is that? Show me.
My lord. The my lord will give me a minute. I'll just show it.
Today, my advocate on record is also has some having some personal difficulty. One of her in-laws has passed away. That is why she could also not come. The Lordship may keep the matter on some other day for framing of issues. And if in the meantime, if we find out that inspection has
We
been
have filed our
completed,
suggested issues as well, my lord. We have filed our suggested issues as well.
So appearing for the plaintiff, so appearing for the defendant. Counsel for the defendant submitted. Defendant.
The communication is also there. The
Counsel for the defendant submitted. He has also already inspected the document available in the bank.
Kindly gives me 1 day because
in presence of the learned commissioner in presence of the learned commissioner. Police. Counsel for the plaintiff submitted. The plaintiff has already disclosed the document to the defendant for inspection by a letter dated 20 March 2024. 2024. Police. Counsel for the defendant prays for time for taking instruction whether the inspection has been carried out or not. Police. This court is of the view. Considering the above, this court find that this court direct the parties to complete the discovery and inspection of the document within a period of 2 weeks from date. Full stop. And to file their affidavit of documents within a week thereafter. Full stop. The plaintiff has already filed the suggested issues. Full stop. The defendant is also directed to file the suggested issues after serving the copy to the learned counsel for the defendant. List the matter on 20 February 2025 for framing of issues.
Grateful.
Give it back to her.
Lord, I am appealing for the petitioner in this matter. My lord, I am humbly seeking for an adjournment yet to get some instruction from the
For what?
petitioner.
Time and again you are taking time.
My lord, what happened in this matter? Both the attesting witness has passed away. And
you wanted to prove the same in the solemn form.
yes, my lord.
Yes.
In respect of that, I am yet to get instruction.
As per the prayer made by the counsel for the petitioner, as per the prayer made by so-and-so Supreme for the petitioner, as per the prayer made by the counsel for the petitioner, the case is adjourned. Let the matter appear on 26th February. Next.
Lord, my application, as per my lord's last order, my lord, the affidavits have been filed before this department of this honorable court. Except, my lord, there is one problem in annexure G. If your lordship kindly takes page 35, my lord.
Page 35.
Page 35. My lord, this is the affidavit of the attesting witness. Where, my lord, the difficulty is, if your lordship kindly considers I, Sanjay Samsundar Agarwal, son of Sri such and such. My lord, the difficulty is, my lord, it has to be Sanjay Agarwal. The Aadhaar card says, my lord, in Bombay, this is the practice. My lord, in any event, my lord, this document was sought to be corrected, my lord. But, my lord, it has been indicated to me by the department that, my lord, unless my lord grants leave, my lord, because this document was executed in Bombay, my lord, the department, my lord, would not be in a position to allow.
What you want?
My lord, if your lordship kindly grants me leave.
For what?
For, my lord, for insertion of, my lord, alias such and such, my lord, the name. In any event, my lord, I have also sent for this afresh, my lord.
Because a
But,
notary, how
my
you
lord,
can correct?
my lord, because, my lord, I have also sent for Bombay, my lord, a fresh document, my lord, which will take, my lord, at least, my lord, 2 weeks. If your lordship, my lord, kindly grants me 2 weeks' time.
So-and-so appearing for the petitioner. As per the prayer made by the counsel for the petitioner, case is adjourned. Let the matter appear on 26th February.
My lord.
Next.
Deeply obliged.
For 58, we beg to appear for the added respondent. But the issue is simple. Honestly, my lord, there was a direction upon us to furnish the death certificate. Now, my lord, we had a talk with our clients, my lord, honestly speaking. But they needed the death certificate. Now, but there is a grievance between the nephew and the aunt. But we were told that on the 8th and the 9th, there was a talk of settlement. Somehow that did not ripe. Now, my lord, except praying for adjournment before your lordship, we have nothing to say at this stage because the death certificate has to be given by the daughter of her father. Now, my lord, she has an allegation that during the lifetime of her father, the aunt did not bother to see. Now, she resides in Barashat and the property is situated in somewhere in Taliganj. Now, my lord, there has to be a settlement because with the other uncle, that is Rudrajit Roy Chaudhary, there has been a settlement. And with this, there has been no settlement as of now. My lord, I will seek only 1 week's time minimum, my lord, so that I can enable my client to make her understand the...
My lord, not required, my lord. There is no question of settlement. I'll just indicate letters of administration was already granted to one of the sons of the deceased testatrix. My lord, I am for the daughter. Now, the father of my learned friend applied for letters of administration. It was granted on May 17, 2024. But before administration of the estate, the father passed away. That is, who had applied for and in whose favor the letters of administration was already granted. Now, we wrote a letter to them that you furnish us a copy of the death certificate so that we can apprise the court that it could not be administered, my lord. And I am seeking today, as a daughter, my lord, I am also a beneficiary in the will, that kindly grant letters of administration in my favor. They initially did not appear. They did not respond to our any correspondence. Thereafter, my lord gave me an opportunity to find out any document which would show that her father had passed away. I believe my learned friend is not disputing the fact that her father had passed away. I had filed a supplementary affidavit in which my lord will see the supplementary affidavit was filed on, affirmed on was affirmed on, my lord, 10th of December 2024. Kindly comes to page number 12 of that affidavit, my lord. I have been able to get a death certificate from the hospital where Bishwajit Roy Chaudhary passed away. Now, today, Bishwajit Roy Chaudhary had the letters of administration in his favor. He has passed away. I, being the other beneficiary in the will, I have applied for the grant of letters of administration in my name. I do not know how the settlement is coming. Her father had applied and got the letters of administration. She sat tight over the matter, did not give us the death certificate. Time and again, even on the last occasion, adjournment was taken.
Who are you?
But I am the daughter of the testatrix.
And who are
she is the daughter of the, she is a granddaughter of the testatrix.
The testatrix had 2 sons, 1 daughter.
Who is the beneficiary in the will?
My beneficiary, my lord, kindly comes to page number 68. Her father and I, both are the beneficiaries in
Other
the order dated 4th of March 2024. Here, my lord, one of the
kindly comes to page number 68, my lord. It's a Bengali will, so I'm just showing the translated version.
My lord, if your lordship kindly comes to the order dated 4th of March 2024.
May I just show the
my lord.
May I just show the will, my lord? The will starts at page 60. It is Bengali. It is the translated version starts at page 68. Kindly comes to page number 69. Towards me, Sri Bishwajit Roy Chaudhary is residing at the address number 75 by 1 Baburam Ghosh Road on the upper floor of my own one-storied house along with family. It is my wish that in my absence, my above said eldest son Bishwajit, that is her father, shall receive the first floor of the said building in the absolute right, including the garage on the ground floor, and shall be in enjoyment and possession of the same as per present arrangement. So her father is getting that. And thereafter, my lord, I myself residing on the ground floor of the said house, my daughter, that is referring to me, my client, my lord, after marriage is residing in the house next door, whose address is 75 by 2 Baburam Ghosh Road, with her husband and children, and nursed me and took care of me and totally looked after me and performed all types of responsibilities. Thinking about the future of my said daughter, I have previously executed a registered settlement letter in Bengali on the date such and such, so that in my absence, she may be the owner of the whole of ground floor and mezzanine floor except the garage. So, my lord, I am getting, my lord, the ground floor and the mezzanine floor, and my learned friend is getting the first floor and the garage, my lord. My lord, the third brother is not, he's not contesting. He has already, he had lodged a caveat initially, but it was discharged pursuant to orders of court, my lord.
4th of March 2024.
So, and my lord will kindly come to page number 119 of my application, my lord. My lord will see on 17th of May 2024, this was the grant of letters of administration in my favor. Everything is recorded, my lord, in my lord's order, which was passed on, my lord, passed on 21st of November 2024. It should be there in the order sheet as well, my lord. So today, all I'm seeking is, my lord, the brother had passed away. Now the letters.
This order was not letters of administration not granted.
It was granted, my lord. That is the order at page 190.
Not issued.
It was granted, my lord. It was issued, but before the administration could be completed, my lord,
on 8th of July 2024, my father expired.
So 17th May letters of administration granted. 8th of July, my lord. Now here's the submission. The father has expired.
That is
now my lord could not pass the order in their absence. So that my first prayer was, let me serve them. I have served upon them. Now they have not been giving. They have not been giving us the death certificate. We have been able to produce.
So what is your prayer here?
My lord, my prayer kindly sees prayer A has already been granted. I'm seeking, my lord, letters of administration with copy of the last will and testament be granted to your petitioner. Prayer B.
Letters of administration, copy and testament. State of yes.
So it's a formality, my lord. It was granted, could not be administered. Now I am seeking letters of administration being the other beneficiary.
But at this moment, she is the owner of the 3/4 of the entire house. Now, this lady, the heir of Bishwajit Roy Chaudhary, she resides in Barashat. There is a bleak possibility that she will be coming to Taliganj to stay here. Absolutely, on a personal side. Now, the difficulty is one of the brother of Bela Kasturi, there is a settlement, and for which the caveat has been discharged by order dated 4th of March 2024.
Correct.
Now, what I'm only seeking, a week's time so that things can settle down.
What is settlement?
I understand, I understand.
Once the court has granted.
Yes, I understand. There is mere technicality, and there is nothing on law point that I could suggest.
You are having your own share in the property.
Yes, that is all right, That is all right. Rudrajit Roy Chaudhary also had a right.
Correct.
That was as of now.
You are having different. You also come.
But as of now, the last instruction that we have received on the 8th and the 9th, the husband of Bela Kasturi had called my client, There was talk of settlement. If at all, I'm only seeking 1 week's time. If things come, otherwise we'll address your lordship on that point.
My learned friend objecting to the will or the letters of administration being granted. Her father had.
But I am on the technical issue. I'm not on the law point, my lord.
So and so appearing for the petitioner, and so appearing for the
what you can
I am the added respondent.
But added respondent, my
Added
lord, as
respondent.
described in the last order.
added respondent. Full stop. Full stop. Counsel for the added respondent. Press for a week time. Full stop. As per the submission made by the counsel for the added respondent, for the interest of justice, the case is adjourned for a week. It is made clear that on the next date fix, no adjournment shall be given and necessary order.
Grateful, my
My lord, and kindly
This is the matter on 31st of January 2025.
my lord, kindly
Grateful,
adds, if my lord indulges me, my lord, kindly adds one line. Kindly ask them to produce a death certificate on the returnable date.
And I address
Everything
your
should be
lordship on the
proper,
possible process. Yes, my lord. Grateful, my lord.
Yes.
59 too. Lord, I appear for the plaintiffs.
I
appear
for the defendant number one.
I had informed your lordship that both the executors, the plaintiffs, have expired, my lord. And my lord, I'm praying for some more time. Just I need some instruction. Perhaps somebody will come up with an application for letter of administration or something. My lord.
When they died? When they expired?
They have died in only 2024, my lord. One, the
then
first,
it will be
one of the
abated.
I know, my lord, I'm just, my lord, if the suit will be awaited, but somebody may come up with letter of administration, my lord.
What is the date of death?
For the executors.
Who died?
Executors.
Executor, they are the plaintiffs now here.
Yes.
They are the plaintiffs now.
So they died.
Yes.
So if they died, who will the suit is abated? Suit where the suit lie?
It's not like because the executors are dead, then the suit is abated.
So
I'm just praying for
when
one
they died,
more
what is
week's
the date
time,
of
my lord.
death?
My lord, one of them have died in July, and the July 2024, and the other died in September 2024. My lord.
24. So
24.
3 months, 90 days is over.
Almost, my lord. My lord, kindly give me one more chance, my lord, because today in the morning, I got a call from one of the sons, my lord. I'll be very candid. Kindly does not record that, but then
Let the matter go out of the list.
lordship.
I'm happy for the petition in this matter. I'm happy for the petition in this matter. The Caveator already took liberty to file a reply on the last occasion. I have prepared a rejoinder, my lord.
Affidavit and reply.
My lord, may I indicate, my lord, I am appearing for the Caveator. My lord, he has filed an application for discharge of my caveat. My lord, to which, my lord, after the exchange of affidavit in opposition and reply, my lord, since new facts had been disclosed in the affidavit on reply, my lord, we had taken liberty from your lordship to file a rejoinder, my lord, where we have basically denied their assertion of facts and given the contrary positive statements. Now, my lord, filing a third rejoinder, then again...
Only one thing, my lord, in the surrender, the point I had to take actually, because they have taken that the deceased was not in a sound mind while signing the document. So I have taken out some documents to show that he was regularly doing the things with the bank transaction he has made, just to show that he was in the sound mind.
Who are you?
I'm the executor, my lord.
You are the executor. Yes. You are the caveator. Yes, so why it is going as a PLA? It is to be contested cause.
Yes.
Testamentary has been not.
My lord, they have filed an application for discharge of the caveat. Hence, my lord, perhaps it is still continuing.
My lord, my advocate is not here today.
What is
my only instruction is, let me file this urgent
What is
on
yes?
the facts, my lord.
So, no.
Because they have taken a point that
maybe that is the cross exam. You made the cross examination.
Yes, there are some documents on it to take on record.
That's not why. That will come.
This can be taken objected to, my lord, at the cross examination.
What objection? You have disclosed the document. They have filed your objection. Again, it will continue in the civil.
This is the last opportunity I want to make.
No, he has taken this point, your lordship, in his affidavit in reply.
Where is your application for discharge of caveat? What is the application for?
My lord, that is GA1 of 2024.
What is the ground for discharge?
My lord, according to my lord, may I respond to your lordship's query?
I'm not prepared, my lord, because my
lord, may I respond? My lord, I tell
your counsel is not there. What?
I'm fully not prepared, my lord.
My lord, let me just answer your lordship's query and then I leave it to your lordship. My lord, the point he has taken is, my lord, he and I, we are both brothers of the testator. Now, my lord, he says
I am the class 2 heir. The class 1 heir, he left behind a daughter who has been untraceable for the last 25 years. This is the admitted position. Yet he says, because there is a class 1 heir, she has chosen not to contest the grant of the probate. Therefore, I have no locus to come and give an objection. My lord, despite the fact that it is an admitted situation that she has that the petitioner has gone and served the citation upon an address in which now it is found that somebody else is living, but he has said very specifically and repeatedly that no, she is living there, but the citation has come back as left.
As per the prayer made by the so appearing for the petitioner, so appearing for the caveator. Caveator or caveatrix?
Well, caveator.
Caveator. Full stop. As per the prayer made by the counsel for the petitioner, the case is adjourned. Let the matter appear on 11th February. Next.
Your Lordship, I appear for the executor in this matter. Your Lordship, in this matter, I am being led by Mr. Krishnendu Gupta. I could see him in court. Yes, he's there. I could see him in court. Lordship, kindly allow me.
Yes.
Lordship, I'm appearing in TS 25 for the plaintiff, and suggested issues have been exchanged.
Mr. Gupta, we are appearing in all the matters, all the three matters.
Appearing in respect of title suit number 4 of 24.
You are appearing for? Who is appearing for the TS 24? Who is the plaintiff in
I'm
TS
for the
24?
defendant. There
Yes,
must
sir.
be.
TS
4 of
24, you are for
24.
the plaintiff. And TS 25?
I am for the plaintiff.
And TS 4?
4, my lord, 4 I am appearing on.
4 and 24, you are for the.
No, only 4.
Who is for the 24?
Lordship, one Aditya Mondal was appearing. I see from the last order, 9 January. Aditya Mondal.
You are the for the 24. So pleadings have been completed all?
Yes, the suggested issues have been exchanged.
My lord, in respect of title suit 4 of 24, there was no direction yet. It was lastly directed on 13 February 2024.
Correct.
The court directed the case to be treated as a contentious cause. Thereafter, the title suit number was given. Thereafter, no direction. This is coming for the This is coming up 24.
You are for the plaintiff. You have not disclosed the document.
No, there was no direction to that.
The plaintiff first.
Lordship, only one thing with the leave of my learned senior, Mr. Gupta, perhaps he has not been instructed by the client. In TS 24, we have give the suggested issues. In that day, the defendant was to give issue that.
Okay, no problem. But all the suit has to be taken as analogous. Now the TS4, the inspection has not been completed. So I am passing a direction with regard to the inspection. Then suggested issues, all the issues can be framed simultaneously. So appearing for the plaintiff in TS number 4 of 24 of 2023. And so appearing for the defendants. So appearing for the counsel for the plaintiff appearing TS number 4 of 2024 submit that no discovery and inspection of the document is completed. Accordingly, parties are directed to complete their discovery and inspection of the document in connection with TS 4 of 2024 within two weeks. Within 2 weeks from date. Full stop. Affidavit of document be filed within a week thereafter. In the meantime, the parties are also directed to exchange their suggested issues. List the matter, list all the suit being TS 24 of 2023, TS 25 of 2023, and TS 24 of 2024 on 19th of February 2025 for framing of issues.
TS 24. In item number 61, Your Lordship.
You are for the plaintiff. Affidavit of documents filed by the plaintiff in respect of TS number 24 of 2023 be kept with the record. Yes.
Your Lordship, only one thing in TS 25, as per the last order, defendant prayed for time to file affidavit of documents. Perhaps that has not been filed. Your Lordship has directed them.
Not filed, not filed. Not will taken.
Grateful.
Lord, in this matter, I am appearing for the petitioner.
Lordship, I beg to appear for the caveator, Lordship.
Lord,
As per your Lordship's order.
My Lord, today in the morning, we have been served with a copy of the. Today in the morning, we have been served with a copy of the opposition.
Copy of the opposition of
Affidavit in support of caveat, Lordship. By video Lordship's last order dated
You are for the caveat. Have you filed the affidavit?
Yes, Lordship.
What is this?
Affidavit in support of caveat. Video Lordship's order dated 23rd December. Your Lordship directed them to serve a copy upon us, and thereafter we have.
Yes. So what do you want?
We have served the copy.
Huh?
I would like to file an objection. Your Lordship will. I need some time to do that, my lord. My
objection.
I mean, I need to take some instruction in this matter, my lord.
No, if this
has to be transferred to TS.
Correct.
And your Lordship
And
will.
then issue will be decided. What objection? This is a written statement.
No. What I meant to say, my lord, I would like to take some instruction in the matter. Your Lordship will kindly convert into TS and
converted, then the instruction of document will come. Then. So and so appearing for the petitioner. So and so appearing for the caveator. Caveator has filed the affidavit in support of caveat after serving the copy to the learned counsel for the petitioner. Let this same be kept with the record. As the affidavit in support of caveat is filed, the PLA 142 of 2023 be treated as contentious cause. Accordingly, the department is directed to assign the testamentary number within a week from date and to place the record before this court on 5th of February 2023.
Lordship. One indulgence, Lordship.
What is the GA1?
GA1 has been disposed of.
Only one indulgence, Lordship. 23rd December's order. My client has name has been wrongly entered. Could it on 23rd December order dated?
What is the name of your client?
Somabrata Mandal.
Somabrata. Somabrata. Somabrata.
Yes, but he's not the appeared. So could it be?
What is the name?
Client's name, Somabrata Mandal. My name.
Chalo. Yes, call the next.
My lord, I beg to appear on behalf of the petitioners. My lord, on the last occasion, your lordship had called for a report from the department, my lord, whether no caveat certificate has been, my lord, issued or not, whether any caveat has been lodged or not.
No caveat has been filed in the above mentioned matter till date as appears from the ledger.
My lord,
Yes.
My lord, we have complied. My lord, this is a non-contentious case. My lord, 4 legal heirs. My lord, 3 daughters. They are the petitioners before your lordship. The mother has, my lord, given her consent. My lord, if I may place the same before your lordship, page 15.
Where is her application?
My lord, page.
Where is the will?
Yes. My lord, will is at page 12. My lord, this is a will dated 1st May 2016.
1st May 2016.
Yes, your lordship, at page 12.
Who is the executor?
My lord, executor are joint executors, 3 daughters. My lord, I shall show.
Testator is Harinarayana Taparia.
Taparia, yes, my lord.
And who is the executor? Where is the name of the executor?
My lord, I shall show. Lordship. My lord, page 12. My lord, there are 3 names. And thereafter, my lord, the paragraph starting with I hereby.
Bangu, Ruma Maheshwari and Bana as joint executrix.
Yes.
Yes, then?
My lord, we made application.
Who are the petitioner? All 3?
All 3, my lord.
All 3 has filed this application?
Yes, my lord.
Joint executrix. When the testator died?
My lord, testator died on, my lord, 5th March 2023. The death certificate is at page 11.
What about the wife?
My lord, wife has given her consent. My lord, the affidavit.
How many legal heirs?
My lord, there are no other legal heirs.
Only wife and 3 daughters?
3 daughters.
Wife
my lord,
has given consent?
My lord, page 15.
Page?
15, my lord.
What is the name of the wife?
My lord, Raj
Dulari
Dulari Devi Tapadia. My lord, the affidavit of the attesting witness is at page 10.
Page?
10, my lord.
Question in the declaration. Where is the affidavit of attesting witness, sir? Where is the affidavit of attesting witness? Who is the attesting witness in the will?
My lord, attesting witness is Sri Gopal Darak.
Huh?
My lord, Sri Gopal Darak.
Sri Gopal Dharak.
Yes.
And Amit Agarwal. Where is the affidavit?
My lord, the declaration is at page 10.
Declaration I have seen. Where is the affidavit? No affidavit.
No, there is.
Then how it can be proved? Yes, what do you want?
My lord, but the declaration is there, my lord.
Sense appearing for the petitioner. In terms of the order passed by this court, comma, the department has submitted report dated 13th January 2025, stating that no caveat has been filed. Full stop. At the time of hearing of the present application, it is found that no affidavit has been filed with respect of the attesting witnesses. And as such, no order can be passed according
My lord, kindly take my lord, para 5 once, my lord, I have stated.
Cases adjourned, let the matter appear on 21st of February 2025. Yes, next.
I beg to appear. Next take is.
Yes.
My lord, I beg to appear. My lord, non-contentious, my lord. The executive 60, my lord.
130. Come tomorrow. Come tomorrow.
This is non-contentious, my lord.
tender my unconditional apology for coming at this hour. I could not have come in the morning. I'm only beseeching leave to file my written statement. My lord, I was under the impression that the vacation days were counted. But the department told me that those cannot be counted, and
The commercial suit.
no, my lord, it's a extraordinary normal suit, non-commercial suit. Determination of Justice Pattonayak, my lord. I only beseech. This is the order permitting me to file written statement within 90 days from obtaining my certified copy of the counterclaim. It is within 90 days if the vacation days are counted, my lord. But the department tells me that those days cannot be counted. Now I'm delayed by 30 days only, my lord. I'm willing to file my.
File an application before the court.
The department, whether leave can be granted to file.
That is my regular code. I don't know whether Justice Patnaik what he has taken.
The determination is
with regard to my code. I have some other procedure. With regard to Justice Patnaik code, I don't know.
Since urgent determination is with your lordship, my lord.
Urgent determination with regard to the acceptance of the written statement. Okay, granted leave.
I'm extremely grateful.
Leave is granted to file in the department subject to acceptance by the court.
I'm extremely grateful.
My lord, Justice Patnaik.
You take this. File in the department.
My lord.
Leave is granted to file the same in course of the day, subject to acceptance by the.
I'm extremely grateful, my lord.
Urgent matter detention, Mr. Justice Viras Patnaik. Unauthorized construction running in the.
It is not the time for mentioning, sir. Yes, call the list.
Item number 1. But I complain of a illegal construction being made, unauthorized construction within a Gram Panchayat area. The last order passed in this writ petition is on 29th of April.
Yes.
There the subdivisional officer issued a notice for a hearing to be given to the parties. I complain of that my neighbor has constructed a property without leaving the mandatory 3 feet area between the two premises. That is the allegation that I make. Now the divisional officer has given a hearing. This is the report my learned friend for the appearing for the authorities, my lord, was saying that report has to be before the court.
I have the report. There are two parts of the report. Initially, a report was issued, my lord, and upon initial hearing, I have the annexures appended to that report. My lord, the second report, that is the final order, my lord, I am devoid of the annexures since, my lord, it was mentioned by my learned friends, my lord. I have the report, final order of the report, but this is devoid of annexures. Or I was hence requesting your lordships at the outset, my lord, at my learned friend mentioned before your lordships rise, my lord, let the matter appear next week so that I can circulate the report in the meantime to them, my lord, with annexures. I have the copies devoid of annexures, my lord. That is the whole difficulty I was facing. I may, my lord, may I hand over the final order, that is final hearing report that has been passed. Yes, I shall, definitely.
It is devoid of annexure.
Yes.
That's the only.
That is the only difficulty, my lord. The initial report, this is the initial report. It is with an annexures. Copy
the first page of the report.
No.
The officers must know is not Kolkata High Court. Still we are in Calcutta High Court.
My lord, I have handed over a bunch of the documents. That is the first initial report that was made over to me. Under section 23, the entire proceeding was initiated under section 23 of the. এটা প্রথমটা দেখো
এটা প্রথম ঠিক আছে যা দিয়েছো রিপোর্টটা দেখতে হবে।
In a statutory authority, being a statutory authority under section 23(5) of the Act, my lord, the SDO.
That I'll place.
Yes. The SDO is empowered to initiate the hearing.
Yes.
What I find from here, my lord, They admit that there is no sanction plan. But what they say that for last so many years, the building is standing over there, number one. Number two, the panchayat did not take any steps. And number three, the panchayat has raised the bills, that tax bills. But that does not make a construction legal, because I purchased the property later and I find that there is not, in my property has trespassed and there is no vacant place in between. So I have to challenge this report, and an exception to this report, that because the background story is
No, whatever it means, they have filed the report.
they have filed a report.
Correct, but the annexes
yes,
are
yes,
not
yes,
there.
yes.
He wanted to disclose the annexes.
Yes.
So I
They have filed two reports.
Yes, initially I have filed a report. My lord, I have handed over a bunch of documents. That is the initial report. Thereafter, a further time was given to the panchayat authorities to submit certain documents, and hence the final report
The
comes.
first one is 3rd of July.
Yes,
And the
yes,
last one is 6th of August.
yes,
So he will be giving me the annexures to 6th of August.
yes. And my lord,
3rd
subject
of
to
July you have received.
Yes, that I received.
my lord, subject to correction of my learned senior friend, my lord, as per the act, my lord, probably if subject to corrections, my learned senior friend's client has to, my lord, challenge this report in way of a fresh writ petition, subject to correction.
That I will. And that will.
Because it's a quasi judicial authority that who has passed this order.
That I will look into it first.
So appearing for the petitioner. So appearing for the respondent.
My lord, there are private respondents. I do not know whether they are
You are appearing for
notified.
whom?
I'm appearing
State-
for the state respondents.
State
Private respondents is also there.
Then appears on behalf of the private respondent.
I do not know whether they have served.
Counsel for the state respondent has filed one report dated 30th July 2024 after serving the copy to the learned counsel for the petitioner. Learned counsel for the state further submits that the subdivisional officer has prepared another report dated 6th August 2024.
But the final order of hearing is 5th August. That's the second page of the report.
Yes, but the said order does not contain the annexes, and he prayed for a week time so that this order and this report can be filed along with the annexes.
Yes.
Accordingly, prays for a week time to file the report along with file the report dated 6th August 2024 along with annexes. In view of the submission made by the counsel for the state respondent, the report dated 3rd July 2024 be kept with the record and is given liberty to file the report dated 6th August 2024 by disclosing all the document within a period of 1 week from date. Let the matter appear. When the regular court is coming?
31st up to 31st, I think the Jalpaiguri.
Let the matter appear before the regular court on 6th of February 2025.
6th February.
Well,
liberty be given in the event I take exception to
both. Let the 6th report both can be both.
I shall circulate the report. Well, should I take back the report on the?
ঠিক আছে আমি থাকো আবার দেবে
এটাই দিয়ে দেবো এটাই শুধু annexure দিয়ে দিই
না let me read it oblige
grateful man.
I am for the petitioner, madam.
Yes.
I am not accepting. I mean, I can't. My land friend is here, my lord.
What is the urgency?
Urgency is that 24 is the closure of the e-tender process, my lord. E-tender process, my lord. Closure. 24. I filed this application only for the ferryguard in dispute, my lord. Ferryguard to allow me to operate the ferryguard without any tender, my lord. Because, my lord, the forefather of the petitioner is the permanent tenant in respect of the ferryguard, my lord. Initially, lease was granted, sublease was there, my lord, and my lord,
subsequently started tender process.
Yes.
Then you are getting
first time tender is started.
You participate So you have participated in the tender?
No.
So what do you want?
Without.
So you may be allowed to continue.
Yeah, with
come with the civil suit before this court.
No.
This court is having the jurisdiction to hear.
Initially, it is second time. First time, they will consider my grievance, my lord, because my lord, kindly see my representation, my lord. Representation.
When the last date? When is the last date?
Day after 2, madam.
So what the?
May I tell now, my lord, the entire story, my lord, that the Raja Rani, that this was belong to some Raja, and then, my lord, then the acquisition process, Estate Acquisition Act came, Then, my lord, this story now and everything in every paragraph, I crave leave to annex. I crave leave. Then nothing. Then said that his predecessor, they once, my lord, they were, my lord, granted the lease with regard to that ferry ghat. There is no such document, nothing.
Yes,
We do not know, my lord. My lord, first of all, my lord, he has no locus standi. He's totally outsider who want to, my lord, stop this process. For last, my lord, 20 years, my lord, this is, my lord, continuing by way of this e-auction. Now, lordship, kindly have a look. This is his second attempt.
Yes.
And it is also, my lord, barred by law of principle of res judicata. My lord, kindly have a look, page number 62. Page number 62 is the, my lord, the order passed in earlier writ petition at his, my lord, initiation. Lordship, kindly have a look, WPA 24151.
Yes.
Here, my lord, the same representation which he now, my lord, seeks that for consideration, that was the subject matter of that representation. And what was the, my lord, the views and observation and the order of the court? That yes, the process of e-auction should be there. And if you want, you can participate there. Now, these order, having not been challenged, this order is binding. He has not challenged. This order is binding. Now he has, my lord, come up again, my lord, stalling the e-auction. The no e-auction, I should be granted.
I
I think, my lord, it should be.
I participated.
Participate.
So what do you want?
Within time.
Order or withdraw?
Allow Mala to participate.
No, participate. It is open, then open.
Last date, Mala. Otherwise, Mala, they will not allow.
When is the last date of opening? 27 January.
Yes, Mala. No.
Publishing the date, document submission 3rd January.
Last date, Mala,
Document
from
submission payment.
3rd January 2025 to Mala, 24th January 2024.
Today we are on
22nd.
22nd.
You fail. You are having
Mala,
time.
tomorrow, Mala, holiday, Mala. So, Mala.
No, the tender process, the terms of the tender cannot be changed.
How
in
the
this
court
way.
can allow
The court
this?
cannot.
Court cannot allow.
Court cannot.
So you are withdrawing?
You can.
You are withdrawing?
One line to allow,
order?
to allow me to submit.
Allow open to everybody.
It is already
Go and
there.
participate.
It is already there.
Go and participate.
Now how can this again you have been allowed to participate?
Yes, Mala.
What do you want?
What?
Withdrawing? So and so suffering for the petitioner, suffering for the respondent, counsel for the petitioner, press for withdrawal of the writ application being 1632 of 2025. Considering the submission made by the counsel for the petitioner, petitioner allowed to withdraw the writ application. The writ petition is dismissed as withdrawn.
Get.
Yes, call the list.
Non-commercial list. Two motions, item number 18.
My lord, item number 18, this is my application for judgment upon admission, my lord.
Yes.
I had indicated that on the last occasion, your lordship was pleased to allow me an ad interim injunction, which was granted on 7th of August, and it is due to expire today, your lordship.
Yes.
So, and your lordship was also pleased to give directions to the parties to file their respective affidavits. Now, affidavit in opposition has been filed within time. And then thereafter, affidavit in reply, I have served on them an advance copy, but I was seeking a week's extension in order to get it affirmed because my client is unwell. That's the instruction I have received from my advocate on record who's present in court before your lordship. So,
yes, what is the submission?
My lord, I would like to file the affidavit in opposition.
Suffering for the plaintiff, suffering for the defendant. Defendant has filed the affidavit in opposition. After serving the copy to the London Counsel for the plaintiff, let the same be kept with the record. Counsel for the plaintiff submit that the plaintiff has already prepared the affidavit in reply and also served the copy to the London Counsel for the defendant. But the same could not be affirmed due to illness of the plaintiff and a press for extension of time, press for 1 week time to file affidavit in reply. In view of the submission made by the counsel for the parties, time counsel for the defendant, counsel for the plaintiff, time to file affidavit in reply is extended for a further period of 1 week. Please.
Counsel for the plaintiff submits that the interim order granted earlier is going to be expired today and prayed for extension of the interim order. In view of the above, the interim order granted earlier is extended till 27th of February 2025 or until further order, whichever is earlier. Let the matter appear on 27th February.
Grateful to your lordship. Item number 19 is also connected, my lord. Let the interim order stands extended there also.
Same order?
Yes, the same order. Yes, affidavit in reply is also served on them, advance copy, but I would seek an extension.
Obliged.
Number 20.
No, item number 20, my lord, I am led by Mr. Soroshish Dasgupta, my lord. He's on his legs. I'll start for the time. My lord, there was a direction for filing a supplementary affidavit on the last day. Disclosing the value of the property that is sought to be sold out there. Well, what I have, along with the, well, I'll just say what I have filed, my lord. My lord, there is a copy of the mutation, the tax receipts, my lord. There is a sanction plan. Well, I've got the property, my lord, the area calculated by a draftsman, my lord, registered draftsman, and then my lord, I've taken out the e-assessment slip, which discloses, my lord, the property is valued at rupees 9 crore 85 lakhs. 9 crore 85 lakhs 27,427.
Where is that?
It was page number 9.
Page number 9.
Well, over here, my lord. Market value. Well, I would also like to say, my lord, in the meantime, well, there was no name to the trust.
9 crore 12 lakhs 37,147.
27,427. This, my lord, this is the market value of the property of the land and the structure.
Where is that?
My lord, I'll show, my lord. My lord, at the bottom, my lord. This is the land value, 9 crores 12 lakhs.
Correct.
Correct. This is land value. And my lord, on the next page, my lord, 72 lakhs is the structural value. 72 lakhs
90,000 is the
structural value. This comes to the total of this amount, this figure, my lord, over here in the market value column. On page number 9, my lord.
Total 9 lakh 85.
9 crore.
9 crore 85 lakh 27,000.
27,427.
These are total.
These are the total.
Including the building.
Yes. What I was also beseeching, my lord, that this trust does not have a name. But we have applied for the plan. We have got the PAN, my lord, that's at page number 12. We also got the PAN in the meantime. We applied for the PAN by this name, my lord, the Tulsidas Mulli Estate Trust. This was granted to us.
Trust.
This is a trust property, my lord.
The name of the trust is Tulsi Malik Estate Trust.
This is not written in the trust deed, my lord. This is the name that we have put because there was no name. We didn't apply for the PAN because all these days we didn't have PAN, no bank accounts. For management of the trust, we already got this PAN card, my lord. This has been issued to us. This trust may be called by this name, my lord, for the time being. But this is one aspect, my lord. I'll just indicate what is the main crux of the matter is. My lord, there are 5 beneficiaries to this trust. My lord, out of 5, my lord, 2 have already passed away. My lord, out of the rest, remaining of the 3, 2 are already the trustees. 2 are the running trustees. One is the sister of one of the trustee. She is getting 250 rupees a month. And my lord, there were 2 sisters of my father, who was the erstwhile trustee. They were also getting 250 rupees a month. But they have all passed away. During their natural life, they were getting this 250 rupees. They have passed away now. My lord, only my sister remains. She is ready to give consent. She is residing in US. She is earning handsome, my lord. She is earning in crores now. She's CEO of a company. She will be giving consent. This is a private trust. Only 2 of the trustees are the beneficiaries. My lord, I can show from the trust deed as well. Only 2 are the beneficiaries. One of the properties trust will be alive. One of the properties will be sold, which is fully tenanted. We'll be selling out in lots and parts because, my lord, if we sell it out in the open market, we won't be fetching much money. Whoever is these tenants are there, we'll be selling it to them. We'll be taking the money, keeping in the trust account. We'll not be using it for our purpose. It's in the trust account. This is what is the main purpose of this application, my lord. Hence the application.
So how you will sell?
Well, by private sale, my lord.
That's why let the publication be made.
Publication be made, my lord. Certainly. If anybody has any objection, well, publication has to be made.
So you both are the trustees.
We both are the trustees. We both are the remaining beneficiaries. One more.
What about the other 2?
Oh, three other were there. They were getting 250 a month. The 2 have passed away because they will be only getting the dictum of the trust.
But whether any meeting has been called for by the trust,
No, my lord, the one of the trust, one of the beneficiary who is getting 250 rupees, she is going to give a consent to this.
That's why the consent, that is different.
A meeting will be
thing.
convened in the meantime.
First, you have to convene the meeting
I have to
and to come with the resolution that all her consent for selling the property.
Yes,
then,
certainly, my lord.
then the court will see, because now the valuation has come. Now the publication will be made. If anybody objection has come, then the objection is to be considered. If it
Certainly,
is not considered, then we'll see who is coming for the highest rate. Then the court will
If
go
somebody else is giving me the highest rate, my lord, that's always welcome. It's because we'll be getting the trust, will be getting the money.
Now, what is the proposed? Have you any persons to purchase the property?
My lord, right now there is one tenant. We only had a talk with them, my lord. Well, I cannot stand on that. We have only oral talks. My lord.
What is the
Further, we
amount?
will be
What is
publishing.
the amount he is offering?
Is 1 crore something for one part of the property. 1 crore only for a part. The part which he is occupying. It's they're running a shop of Manyavar, the clothing store is there. He's occupying the major portion. He's one the portion. He's ready to buy that portion. He's already is a registered lessee. He's already there. The lease deed is also there. He's a registered lessee. He's paying around 3,000 4,000 rupees a month, my lord. Now,
So
what
in
is
the Manyavar, how you can? What is the rent he is paying?
3,000, my lord? It's an old lease, my lord. Under the lease,
How many tenants are there?
At least 30. Well, I annexed all the rent bills. I have given the I can also show from my document, my lord. I have also given the balance sheet. How much I am getting. It's more than what I am spending. It's less than what I'm spending on the property. I can indicate, my lord. It's available at page number. I annexed all the documents.
So now what you want at present now?
Well, at present, I want to sell it by a private contract, my lord. Maybe the money will anyways come to the trust. We are the beneficiaries.
Come. First you conduct the meeting, sir.
Yes, I will conduct the meeting in the meantime.
First you conduct the meeting, come with a resolution.
Yes, madam.
All are having the consent, then we'll see to that.
Yes,
So appearing for the
publication will be done in the meantime.
First come with the resolution. Come petitioners. Solicitor. Counsel for the petition submitted. The petitioners are the two trustees. And apart from the two trustees, there are other three beneficiaries.
Well, there were three beneficiaries, two have passed away.
All.
2 out of the 3, 2 have passed away.
Correct. Other three beneficiaries. There are other three beneficiaries. Out of 3, 2 beneficiaries have been passed away. And 1 beneficiary is still alive. Full stop.
Second petition is system.
Full stop. Considering the above, this court full stop. This court find that the petitioners, being the trustees, have filed the present application praying for leave to sell the property in question. But the beneficiary, neither the beneficiary have been made party, nor any minutes of the meeting of the trust is disclosed in the present application to ascertain whether the trustees have taken the consent of the beneficiary to sell the property in question. Accordingly, the petitioner is directed to produce the resolution of the trust to show that a meeting has been conducted and a conscious decision has been taken to sell the property of the trust. Let the matter appear.
Mr. Dasgupta is
Only one prayer, my lord. The lordship is keeping it on the. I will hold the meeting and we'll get the consent. She's already ready and willing to give her.
Come with the resolution. Come with the resolution.
Maybe make the publication in like your lordship passes order in that manner. So it will save time.
Come with the resolution first. How soon you will
both
file?
parties both trustees are there before your lordship.
How soon you will file?
কবে আসছে বললে কলকাতা?
কলকাতা চলে আসবে তো জানুয়ারিতে আসবে।
In this month he's supposed to fly from US. So because both the trustees are here before your lordship. So meeting between the trustees, they are already parties here and they have jointly filed this application.
Let come 6th March, 6th February.
Grateful.
Next.
Appear on behalf of the defendant.
Yes.
I
Settlement
would
is going on.
Yeah.
They have approached.
We have formally approached them. Lordship kindly keeps it after a month. Whatever we come up with.
My land senior, his senior was asking for 15 days time. So I was praying for if my lord is pleased to fix on 5th or 6th of February.
There will be a pressure, otherwise not the.
As per the
Yes.
so appearing for the plaintiff, so appearing for the defendant, as per the prayer made by the counsel for the parties. Let the matter appear on the non-commercial, na?
Non-commercial.
12th February.
I'm not.
See the diary.
I'm not. Not then on 13. I will return on 12th.
13
Grateful.
February.
Grateful.
Next.
22. Also, with this matter, I appear for the plaintiff petitioner my injunction application. Also, I am being led by Mr. Ritobrodo Mitra. Yes, I find him in this. He's there.
Matter, we are appearing for the respondents, my lord. Defendants.
G1. My lord, this was in respect of there's an order passed by Lordship, an interim order. My lord, in GA1, there are now 2 applications, my lord. In fact, today there's just 1 application appearing, GA3. GA3, my lord, is an application filed by the respondent, my lord, for vacating, my lord, your Lordship's interim order, which was never moved. Now, unfortunately, my lord, on the last occasion, Lordship kindly sees the order. What, Pushan? Lordship has the order, my lord, of January 14.
Yes.
Lordship will find that it's GA3 in which the interim order has been extended. And, my lord, directions have been given in GA3. My lord, I'm told, my lord, it was GA1 in which directions were given. It's wrongly, my lord, this is a typographical error. GA3 was never moved. So GA3 is appearing today, my lord, for, my lord, directions to file affidavits. So, my lord, Lordship can pass the directions. And, my lord, in GA1, my lord, the interim order expires today, as your Lordship has seen, my lord, from the order.
GA1 has.
It's not in the list, but it expires today, my lord.
Today?
Yes, my lord. Tomorrow, I'm sorry, 23rd.
Tomorrow.
So you have filed the affidavit in opposition in that
Yes,
GA1?
they have filed. Yes. My
Yes,
lord, may I
this
file
is
the
the
reply
opposition.
also, my lord?
This is opposition. We are filing it, my lord.
So appearing for the plaintiff. So appearing for the defendant. Counsel for the plaintiff brought to the notice of this court to the order dated 14th of January 2025 and submits that on 14 January 2025, this court has taken up for hearing with regard to GA1 of 2024, but inadvertently in the cost title and in the order it is recorded as GA3 of 2024. Though the GA3 of 2024 is listed before this court only today. He further submits that the direction passed in this set, the direction passed on 14 January 2025 is in connection with GA1 of 2024 and a direction be passed in GA3 of 2024 for filing affidavits. Considering the submission made by the counsel for the plaintiff, the order dated GA 14 में GA3 नहीं था, GA1 था. Considering the submission made by the counsel for the plaintiff, the order dated 14 January 2025, in the order dated 14 January 2025, the GA number shall be read as GA1 of 2024 in the cost title as well as in the ordering portion instead of GA3 of 2020. As regards GA3 of 2024, the plaintiffs are directed to file affidavit in opposition within a period of
2 weeks.
2 weeks. Reply, if any, there to be filed within
2 weeks.
2 weeks thereafter. Full stop. Counsel for the plaintiff submits that the interim order granted earlier is going to be expired tomorrow and press for extension of interim order.
Yes.
In view of the submission made by the counsel for the plaintiff, the interim order which is going to be expired tomorrow is extended till 27th of February 2025 or until further order, whichever is earlier. List GA1 and GA3 of 2024 on 27th of February 2025.
April.
The affidavit in opposition filed by
February.
The affidavit in opposition filed by the defendants in connection with GA1 of 2025 and 2024 be kept with the report.
Also the reply. I filed the reply as well.
Affidavit in opposition and affidavit in reply be kept with.
I'm great. Very great.
Number 23. Your Lordship, in item number 23, I'm led by Mr. Rupak Ghosh, Your Lordship. He's stuck in some other court, Your Lordship. This is an originating summons suit, Your Lordship was pleased to admit it on 15th of January and made the matter returnable today, Your Lordship. Your Lordship should keep it some day coming week or thereafter.
As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 12th February.
Deeply obliged. Item number 24.
My lord, item 24 is my application, my lords. My lord, for settling of my originating summons application, my lord, for settling of 4 questions, my lord. This is my application for my lord, settling of 4 questions, my lord, arising out of 2 connecting trust deed, my lord. There was an earlier trust deed of 11th December 1925, where my lord, the settler has invoked the provisions for maintaining of the Shiva Puja by the male descendant and as well as the female descendant. Subsequently, in 26th of September 2020, 1926, another subsequent
notice.
No, my lord, after admission, my lord, that can be, my lord, someone can be issued, my lord. So, my lord, this is appearing for the first time, my lord.
First time?
Yes, my lord. And the questions, my lord, that is in page.
What are the questions?
My lord, firstly, whether the difficulty is facing with the petitioner, my lord, the lineage of descendant, my lord, the petitioner is having 2 daughters, my lord. My lord, in absence in the provisions as per the subsequent deed or endowment, my lord, the Shiva Puja can be only performed by the male heirs. My the petition is only having 2 daughters. So in that absence, even my lord, there will be certain difficulties, my lord, certain modification is required to be done, my lord. That is the 4th question. First question, whether the clause of the appointment of the Shiva is contained in the supplementary deed of endowment dated such and such either.
Mr. Banerjee, one order is passed regarding the female member was then that has been modified. No?
Yes, that share matter.
Share matters. Yes.
My lord, does override the original deed of endowment, because of the original deed of endowment, the right of Shiva performing Shiva Puja was given to the female heirs. So in the subsequent deed of endowment, that right has been taken off. Second question is that whether the settler by executing the supplementary deed of endowment dated 29th September to 1925 could have been laid down in a line of successor of the Shiva restricted only to the male descendants.
So you are not having a male descendant?
I am not having, not only me, the petition, there are other persons also, other trustees who are not having the male descendants.
Nobody?
Nobody.
None of the trustees?
None of the, some of them, or some of them are not having. That is the difficulty facing by the commonly facing, but all other persons are not coming before the court.
Okay, let the issue note.
Let the issue, my lord.
The originating summons suit is admitted, subject to scrutiny by the department. Full stop. Issue notice. Issue notice.
Item number 25.
My lord, in this matter, I appear for the plaintiff, my lord. There are 2 GA applications filed by the defendant. My lord, in GA1, I would like to file the affidavit in reply. I have served them within time. Thereafter, it was affirmed on 2nd of July. Thereafter, the matter didn't appear in the list. So we could not file the affidavit in reply to the GA1, my lord. And the GA2, it's appearing for the first time, my lord. They have filed this application for condonation of delay to file their written statement. And my lord, if you take up the...
Appearing for whom?
I'm appearing for the plaintiff.
GA3 is?
GA2.
GA2. GA2 GA3 is
GA3. GA3 is their application for condonation of delay to file the written statement. My lord, if you take up the...
39 days in filing written statement.
My lord, if you take up the application, there is no annexure annexing to the points they have taken, like change of advocate, medical reports, nothing is annexed, my lord. So I would like to give a reply, or this application may be allowed subject to payment of cost.
Lordship, I beg to appear for the defendant number 1, 2, 3.
And affidavit in reply to GA1.
Yes.
Lordship, this is an application for condonation of delay of 139 days.
So,
my prayer is kindly we accept and
Subject to payment of cost, my lord.
3 dependents.
Yes.
3 dependents.
3 dependents.
You will file 1 written statement or 3 written statement?
I have filed 1 written statement.
1 written statement. So,
As I was instructed that this
tell
is
what the cost you will pay.
Kindly Lordship take the minimum cost.
What is the minimum prescribed under law? Yes.
My lord, subject to payment of cost, I shall not object.
Lordship, kindly consider the payment of cost. That actually the matter was earlier in appearing another advocate, and he has not.
No documents annexed to the application. Is
But
not a single
139 days delay. When you receive the writ of summons?
long back, my lord.
March 2024.
And they have filed 1
1
GA
year going to
application.
pass. And when you file the application?
Very recently.
December.
December, 23rd December.
March you received. December you filed. Where is the written statement? Ready?
The matter
Not ready yet.
Written statement not ready.
Wakalat now.
Come. How soon you will come with the written statement? I am fixing this application.
Yes.
With the check amount of rupees 20 lakhs.
No, Lordship.
When you will file the written statement? When you will bring the written statement?
Written statement, my lord, is prepared but not affirmed.
And not affirmed. How can
So
you
how soon? I am fixing on Wednesday.
And my lord, in this matter, I am being led by Mr. Rudraman Bhattacharya. I shall
kindly allow 1 week. Lordship, kindly allow me 1 week for filing written statement.
Defendant has filed an application being GA3 of 2024, praying for extension of time to file written statement. But it is found that the defendant is not ready with the written statement. Accordingly, the case is adjourned. Let the matter appear on 30th January 2024.
My lord, my affidavit in reply to GA1 may be taken on.
GA1 is not here.
So GA2.
GA1 is not here today.
GA1 is
Next.
1 is also not there.
This is my application for amendment, my lord, with respect to a fact which was, my lord, informed to us by way of the affidavit which was filed, my lord, at the stage when we were moving the injunction application. Lordship will remember, my lord, wherein Lordship had granted injunction not to, my lord, deal with the shares, since, my lord, they had, my lord, transferred it. Now, my lord, in that we came to know that, my lord, from the demat account which was held, my lord, with Aditya Birla, my lord, they have, my lord, during this pendency and all, transferred it to Motilal Oswal. So this small amendment is what, my lord, has been brought in. Now, my lord, to this, as a matter of right, my learned junior friend wants to file an affidavit. My lord, that should not be allowed. Why I say this, my lord? The only issue is that I find that, my lord, although, my lord, master summons have been taken out, but, my lord, it is in the form of a petition. So, my lord, in terms of the, my lord, the original side rules, chapter 4, chapter 6, sorry, rule 4, my lord, it should be in the affidavit form, my lord, but these things have been dealt with. I can at least give 1 division bench and 2 single bench judgments, my lord, of this court, including one of my lord's coordinate benches, saying that this is a procedural thing. If the, my lord, facts are correct, my lord, only these technical issues should not be looked into. It should be allowed, even if it is, my lord, in the form of a, my lord, petition, because, my lord, it's a very technical issue. It will not, my lord, cause any hindrance to the entire cause of action, or, my lord, is not even beneficial to any of the parties, except that I have to withdraw and file it again, paying another court fees. That is all. So, my lord, this is the little thing which, my lord, I think with regard to the
application for GA3.
Yes, my lord. With regard to the, my lord, amendment, I don't think my learned friend can have an objection, because that is what I came to know from their affidavit itself.
Yeah, they informed us by UF letter.
So, my lord, that, my lord,
Informative.
হ্যাঁ এইটুকুই আছে, সেই জন্য তুই অপোজ করছিস।
আরেকটা আছে না, দুটো অ্যাপ্লিকেশন
দুটো আছে, দুটো সুট আছে, দুটো ফি পাবি তুই। So that is all is there, my lord. So the objection, I believe, is in the form.
No, also to the amendment that he seeks.
The amendment, though, he's
Where
been
is the
informed by
objection?
them.
No,
Where
it's
is the
coming up.
proposed amendment? Where
It
is
is
the
coming up. The portion, my lord, lordship will find. Page 282, lordship kindly takes. 282, I have added a party because, my lord, my learned friend has informed that now it is with Motilal Oswal. So obviously, my lord, I have to, my lord, kindly takes volume 2, my lord.
282?
282, my lord. Kindly sees, my lord, 6 has been added because this they inform Motilal has now got the account with them, wherein he has transferred these shares. Otherwise, lordship's order will become infructuous, my lord. Now, my lord, 6 is what has been added, and the other, my lord, 283 kindly comes to A, 283 in support of the statements made by them, my amendment, and then, my lord, kindly comes to 285, paragraph 7A. My lord, kindly sees plaintiff state that recently it has come to the knowledge of the plaintiffs that the defendant numbers 1 and 2 have further committed illegality by getting the subject shares involved herein transferred from the account of defendant number 5 to demat account of defendant number 6 herein, Motilal Oswal, such and such, registered office in the aforesaid jurisdiction. Then, my lord, 286, Roman 3. Again, my lord, the same facts which I came to know from them.
301.
And kindly, my lord, takes 301. Next volume, my lord, 301. Entire amendment is based on, my lord, the facts which have been stated by them in their affidavit in opposition, my lord, file. The first page, my lord, next volume, 301 at the bottom, double A. Double A and BB, my lord.
Yes.
And then thereafter, my lord, 312. The same, my lord, BB that I showed. So this, my lord, I believe, my lord, is nothing but, my lord, a fact which they told us, which we want to include.
Opposing, what? Tell you, Lordship, why? Kindly have a look at the praise in the suit. So Aditya Birla was defendant number 5 in the suit. Their case is that I have informed them that this has gone from Aditya Birla to X. X is irrelevant, it's gone to X. Your Lordship has injuncted, their injunction order is there. There is no case that there is any violation, that's separate. Kindly have a look at the praise in the suit. The amendment must relate to the suit. Knowledge is irrelevant. He had, as D5 was there, even against Aditya Birla, there were no reliefs claimed. It's irrelevant whether Aditya Birla money has gone to someone else. This amendment is beyond the scope of the suit itself. How he acquires knowledge regarding a party has no relevance to the suit. Please have a look at the praise in the suit. Instead of D5, it's gone to, let's say, D6, who is going to come in. But D5, there should have been some relief. Prayer A, decree for declaration, plaintiff number 1, D3, D4. Just gives it a cursory glance. Your Lordship will not find D5 anywhere. And damages he's claimed for against D5, prayer H.
Yes, 1, 2, and 5.
1, 2, and 5. That's damages against D5. So for that cause of action also, this new party has no relevance. So there were no reliefs claimed in respect of this proposed added party or even D5 with regard to the shares. Today, based on this knowledge, he can't enlarge the scope of the suit. That is what he's trying to do here. And I'll be able to show, it sounds very nice to say I've got knowledge from X, I want to implead Y. But from that conduit between X and Y, there must have been some cause of action. That I had reliefs against X. Now that the money has gone to Y, I can't get reliefs against X, therefore I need Y. Normally that's amendment. There was nothing against X.
Have you filed the affidavit?
No, that's what I want.
May I just give an answer to that?
I'll file the affidavit. I'm also in the affidavit, I'll formally take the plea because I also have decisions which say that when it has to be under master summons, it has to be supported by an affidavit, then the form will have to be followed for a particular reason, that somebody needs to come and take responsibility of the affirmation that he makes in aid of prayers that are there in the master summons. These original side rules are procedural, that also there is a judgment, but I'm praying for an affidavit to show that this knowledge that he has nothing to do with the amendment that he seeks.
because the amendment enlarges the scope of the suit today.
Yes, my lord. My lord,
So I'll just wait for an affidavit. Not
first of all,
2 weeks I'll file an affidavit.
very well, I'll come back with an affidavit. Since he wants to, my lord, delay the proceedings, let us
Why
go
delay? Just carry on with the suit.
When suffering for the plaintiff, when suffering for the defendant.
Or kindly fixes a date and a time, my lord.
Plaintiff has filed the present application being GA3 of
March
2025 for amendment in the plain.
কেন আমাদের তো তাড়া আছে
Defendant number 5 and
1 and 2.
1 and 2. Defendant number 5. 1 and
নতুন জাজ অ্যাপয়েন্ট করছে পেন্ডিং হয়ে যাচ্ছে বলে
time
সুপ্রিম
to file
কোর্ট
affidavit in opposition.
রিটায়ার্ড জাজেস
Let affidavit in opposition be filed
within
within 2 weeks. Within 2 weeks.
I believe his brief is the best one. He should also earn one.
1, 2, and 5. Let affidavit within 2 weeks. Reply if any by 2 weeks thereafter.
Why 2 weeks?
1 week.
1 week, my lord. 1 week.
1 week thereafter. Please to please the matter on the non-commercial.
No, non-commercial lordship fixes a date and time, my lord.
Date and time
for amendment.
Yes, because my lord, I have to proceed with the suit, my lord. Today, my lord, I was not showing that notification. The gentleman is 90 years old and his wife is 83.
18 है sir. 19th of February under the heading adjournment.
Great. At 2 p.m. My lord, it won't come up, my lord.
There is no time.
Any day lordship has time, I'll come back, my lord. On that day, I'll
go to the March. That is the problem.
May it be March, my lord. May it be March, my lord. At least I'll be happy that my matter will be taken up, my lord. I understand my lord's, my lord, heavy list, my lord.
Let the matter appear on. Give the date. March, which date? 14, 15.
13. I've got a lucky day, my lord.
13th March.
Let's see if it's a Friday.
Ides of March.
3 p.m. 3 p.m.
3 p.m. Grateful, my lord. Na, ajgeo ache.
Grateful.
26 and 27 both.
Yes, both, my lord. Two matters, separate orders, my lord.
Separate order.
My lord, there is, my lord, one issue. My lord, in the second matter, he is only appearing for one. There is no two. Two is not appearing.
But two separate.
1 and 4. And it's 1, 2 and 5.
Correct.
Two separate orders are crucial for us.
Yes, of course.
Original side.
That is also because of the original side, my lord.
That's why I'm telling you. Original grateful. That's why today,
my lord, it's in the appellate side also.
Now, today, that's why I've taken 2 matters of the appellate side. Then I told my officers, see, it is very easy in the appellate side.
No, my lord, nowadays they too, especially, my lord, if you are appearing for the state or Union of India, an order is must. Order is must. Grateful, my lord.
My lord, I'm for the respondent, my lord.
Lordship, that is our application and chapter 13. Lordship, may I file reply?
My lord, may I file my affidavit in opposition, my lord? My lord, I'm humbly praying for 1 week's time, my lord. For the hearing of this affidavit in opposition and this application, my lord, filed under section 13A, my lord. My lord, I'm praying for 1 week time, my lord.
Yes, my lord, may fix it in the next week, Lordship.
Sense appearing for the plaintiff. Sense appearing for the defendant. Plaintiff has filed an application being GA3 of 2024 under chapter 13 or
13A,
order
my
13.
lord.
Yes, Lord. 13.
13A.
Chapter 13 or order 13?
Chapter 13A, my lord.
Chapter 13A of the original side rule for summary judgment. Full stop. Defendant has filed affidavit in opposition, comma. Plaintiff has filed affidavit in reply. Let the same be kept with the record. As the pleadings have been completed, list the matter on 12th February for hearing of GA3. Next.
I'm obliged, my lord.
Lordship, I appear on behalf of the petitioner defendant.
25.
29.
29.
Lordship, this is only for acceptance of written statement. My written statement has been affirmed, Lordship. I took out an application on that very same date.
What is the delay? How many days?
106 days. I was contesting the suit, my lord. The injunction order has also been confirmed, my lord. There has been a repeated representation. The only thing, there were old documents, Lordship, which I could not file at the time of I would have ideally filed it within time, Lordship, but those documents were not there. It's a suit for eviction on the grounds of default and subletting.
Yes.
My lord, in this matter,
Hmm.
Senior Advocate Manju Agarwal is appearing for the plaintiff. There has been a bereavement in her family. Her mother passed away. So please adjourn the matter for a period of fortnight.
Written statement. You're not in no instruction.
Actually, I'm
Lordship, they have also taken out an application under Chapter 13A.
Yes.
That is there. That's a different GA that we
It's
that
a
we will
written
deal with.
statement. Let the written your chapter 13 application.
no, actually, I don't know the matter. I am very new in her firm. Actually, I joined last week.
Son suffering for the plaintiff.
I'm obliged, my lord.
Son suffering for the defendant. Please, the plaintiff, the defendant has filed an application being GA2 of 2024, praying for extension of time to file written statement. Police counsel for the plaintiff prays for time. According case is adjourned. Let the matter appear on 13th February.
Lordship may kindly record that the written statement has been affirmed on 14th of
Okay, I will take.
Lordship may kindly record that.
Police counsel
I'm great.
for Bolano filed an application for
Acceptance,
extension
my
of
lord,
time.
acceptance.
Extension of time to file written statement, as the written statement is already been affirmed
On 14th
on
November.
14th of
November, my lord, 2020.
2020.
Lordship has kept it on 13th.
13.
I'm
Lordship,
opposing it.
Lordship, I'm so sorry. Lordship, 13th, I'm in some difficulty. Any other day? Excuse me. Sister, do you have any other day other than 13th?
12,
12,
12 कर दो. Yes, 30.
Lordship, I'm opposing both the applications.
Nobody is there to whom I'm opposing.
We are for the plaintiff. They have filed an application
Who?
for
What is the
defendant
application?
number 1 and 3.
What is the
The
application
separate
for?
applications they have filed
For
dismissal of my suit.
dismissal of the suit.
They're saying this is a commercial dispute. Maybe use our affidavit.
Dismiss the exemplary cost. What is the suit for?
Damages, Your Lordship.
Yes, who is appearing for the
I'm for defendant number 3, your lordship.
yes. Defendant number 3. Who has filed this application? J1? Defendant number 3.
Defendant number 3 is
Yes.
GA1.
Have you filed affidavit? You will file affidavit
Yes,
now?
we'll file affidavit.
You file affidavit.
In both, Your Lordship, there's GA1 and GA2. In both, we'll file affidavit.
What is the GA1?
There's by another defendant.
an application
Same.
For same. For the
rejection of
dismissal.
plain.
Rejection.
Filed by the defendant number 3.
GA1 is for the of the defendant number 3.
One is defendant number 3, another one is defendant number 1.
GA2 is for
Defendant number
1.
GA2.
no. Your lordship, GA1 is for defendant number 3.
Correct.
GA2 is for defendant number 1.
So and so suffering for the plaintiff. So and so suffering for the defendant number 1 and so and so suffering for the defendant number 2. Defendant number 1 and 2 have filed 2 separate applications, being GA1 of 2024 and GA2 of 2025.
We would like to file a reply to
Praying for rejection of plaint. Counsel for the plaintiff prays for time to file affidavit in opposition in both the applications. Let affidavit in opposition be filed within
Period of 2 weeks.
2 weeks, reply if any there to be filed within a week thereafter. Please the matter on 26th of February 2025.
Your Lordship, it will be defendant number 1 and 3, Your Lordship.
1 and 3.
Grateful.
Grateful, my lord.
Lord, if your Lordship recalls, I have made an application under Order 7, Rule 11, Lord, for rejection of the plaint. Now, I'm being led by Mr. Bose. Mr. Bose was, my Lord, making his submission. Lord, this will take some time, my Lord, because he hasn't finished off with his submissions, my Lord. We are yet to, my Lord, place the whole of the plaint and, my Lord, certain, my Lord, judgments and all. My Lord, I believe.
Subject to your Lordship's pleasure, my Lord, we are making a joint prayer for not today.
Because, my lord, another matter is fixed before your lordship at 3 p.m. And today, my lord, at 3:30, the court has to rise. As per the prayer made by the counsel for so suffering for the plaintiff, so suffering for the defendant. As per the prayer made by the counsel for the respective parties, the case is adjourned. Let the matter appear on 19th February.
19th February.
Next.
32, my lord, I am appearing for the plaintiff, my lord. In this matter, my lord, defendant number 3 has passed away, my lord. We have to file the.
You are appearing for plaintiff?
Plaintiff.
Ah.
My lord, we have to file, my lord, substitution, my lord. Although, my lord, substitution application is ready, my lord, but.
Defendant number 3 passed away.
3 passed away.
Counsel for the, as per the prayer made by the counsel for the defendant number 3, they can say adjourn.
On the last occasion, they have taken the adjournment. We need 2 weeks time to file our substitution application.
So suffering for the plaintiff. None appears on behalf of the defendant. Counsel for the plaintiff submit that the defendant number 3 passed away and he requests 2 weeks time to take appropriate steps. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 27th February.
Great.
Next.
My lord, I'm appearing for the plaintiff, my lord, in item number 33, lordship. My lord, my application under Order 12, Rule 6, my lord, was being heard, my lord, and the defendants are yet to conclude their submissions, my lord. My lord, there has been a change of brief as well, lordship, in this matter, my lord. I can't, my lord, I'm not sure, my lord, if the defendant is appearing today, my lord.
It will be a long submission, my lord. We rely on several judgments. At 3 o'clock, my lord, has a fixed matter. So I may pray for pass over. Pass over it will not be possible today because at 3:30 court will rise. So not today. I am praying for not.
So suffering for the plaintiff, so suffering for the defendant. As per the prayer made by the counsel for the defendant, the case is adjourned. Let the matter appear on.
Tomorrow, my lord, I have no difficulty.
Let the matter appear on 30.
Fixed time may be given.
30 January 2025. Yes, next.
Grateful, lordship.
My lord, I am for the respondent.
And I am for the defendant, my lord. This matter, Mr. Chaudhary was appearing for. We were arguing about the date. And
yes, my lord, that matter where your lordship was of the view that if a gate is, my lord, constructed, the right to privacy, your lordship, is protected, your lordship. So this was the view. Accordingly, my lord, talks of settlement was going on between both the parties. Lastly, matter
it was
heard.
decided that we will proceed with the hearing of the injunction application. My lord, Mr. Chaudhary, on the first occasion made a substantial submission, my lord. My lord, if my lord wants, he can again start his argument afresh, my lord. Then they can reply, my lord, whatever will fall from this honorable court, my lord.
If my lord so please, any day might be fixed. Keep it to that.
And the interim order is expiring today, my lord.
Suffering for the plaintiff, suffering for the defendant.
Next.
As for the prayer made by the counsel for the parties, the case is adjourned. And the counsel for the plaintiff submit that the interim order granted earlier is going to be expired today and paid for extension of the interim order. In view of the submission made by the counsel for the respective counsel for the plaintiff, the interim order granted earlier is extended till 26th of February 2025. List the matter on 20 February 2025.
23.
Deeply obliged.
My lord, I am for the plaintiff. Same position, my lord.
Yes.
Already 3 o'clock. I am for the plaintiff.
What is the application?
Application is for injunction and attachment. Injunction for attachment and etc.
As per the prayer made by the counsel for the plaintiff, the case adjourned. Consistent appearing for the plaintiff, none appears on behalf of the defendant.
Defendant is not appearing, my lord.
For the interest of justice, the case is adjourned. Let the matter appear on 27th February 2025.
30th January may be given. Earlier date may be given.
Next. Fixed matter. Yes.
The suit for malicious prosecution. Lordship has been kind enough to hear it before. But just to remind your Lordship, not immediately only with regard to the basic fact, with regard to the cause of action pleaded, your Lordship will kindly please come to page 31 of your Lordship's brief. This is part of the plaint.
Yes.
Because your Lordship will be rising after a little while. So, may I take your Lordship's time to yes, please.
Release.
Item number 31. I will not be able to complete today. So if my license want, they want. I don't want to stop them in their revenue generation also.
My revenue generation has been lost. But your Lordship, that Order 7, Rule 11, item number 31, your Lordship has kept it on 19th February. Just the other side, just 1 minute before this matter, item number 31 was called. In that case, let it be fixed at a particular time so that it can be finished off.
Time the problem.
Otherwise, let it appear in the list in the regular course every Wednesday or
No,
Thursday.
that's why I'm coming. Let in this.
But 19th is too far away. At least we can take our.
Who's for the other side?
Other side, Mr. Moinak Bose was there.
He left.
But let us.
Mention, I will take.
Let it remain in the list as usual. We take our chance.
Lordship, may I mention your Lordship?
Case is going on. What is going on?
Released.
Release.
No.
Yes. All matter released.
The prayers of the plaint are at page 34. Your Lordship will find that the primary relief is of 10 crore as pleaded in paragraph 24.
Yes.
Now, Lord, if your Lordship is kind enough to take paragraph 24 at page 33, it has nothing to do with the relief claimed. So I think that is
21.
That's a misnomer.
It's a typo.
That's a typographical mistake. I'm not laying too much of emphasis on this, but it is really 21.
Yes.
Now, Lord, the substantive prayer is in relation to paragraph 21. By reason of the aforesaid malicious prosecution, the plaintiff's reputation has been irreversibly tarnished. Now, Lord, the reputation is by reason of malicious prosecution. Now, Lord, malicious prosecution has been pleaded in paragraph 20. And Lord, the cause of action is the plaintiff numbers 1, 2, and 3 have an absolutely clean reputation with no past antecedents of any civil or criminal litigation against them. The plaintiffs state that the malicious prosecution set in motion by the complaint of 17th October 2020 has stood concluded with the final report dated 25th January 2021, already annexed. The frivolous complaint leading to the FIR was registered outside the jurisdiction, while the investigation thereof was conducted by the plaintiff within and outside the aforesaid jurisdiction. So, according to the cause of action, this is the cause of action. So, beyond this, I need not trouble your Lordship further. Whether the complaint was rightly done, wrongly done, whether the criminal proceedings have been rightly set into motion is irrelevant. The question is, has the basic ingredients of malicious prosecution been satisfied?
Yes.
If they have been satisfied, then it's a question of trial. Not in my respectful submission, the malicious prosecution can be set in motion when there is a complaint, the complaint is investigated. Now, Lord, in terms of the earlier Criminal Procedure Code, not the present BNSS, Lord, report is filed. Lord, by the police in final form, either saying that there is requirement of a trial or no requirement of a trial, it's filed before the jurisdictional magistrate. Now, the report in final form in terms of the Criminal Procedure Code is not the conclusion of the investigation, nor is it the conclusion of the complaint.
Unless it is accepted by the court.
When it comes before the magistrate the magistrate gives a chance to file a
Yes,
Narazi petition.
magistrate is having two options.
Either accept it,
Or-
three options.
Yes, three
Either
options. Or
accept
issue-
it, or ask for further investigation, or reject it. If the investigating officer in his wisdom says that no cognizable offense is made out, or there is no evidence, then there is a process of a Narazi petition also being
Proceed
permitted
with
to
that,
be
yes.
filed. So at the end, it does not come to an end there. Lord, I have got for your lordship's consideration a judgment of the Supreme Court which gives all the options available before your magistrate to show your lordship, Lord, that paragraph 20 does not result in the end of the process which can let malicious prosecution to be set in motion. Lord, if your lordship is with me on this proposition, that filing of final report
Unless
by
it is adjudicated.
unless it is adjudicated by the magistrate and the magistrate agrees with the final report that no offense is made out, therefore the charges need not be drawn up.
So what is the stage of the now this case?
Now, my lord, so far as the final report is concerned, your lordship will find that here, your lordship, please comes to page 96. To the best of our information, my learned friends will be able to tell your lordship further. The lordship is pleased to see, Lord, this is the Naraji petition at page 96. Lord, the report in final form, which was filed before the Lord ACJM, that is at page 63, 25th January 2021, which is referred in paragraph 20. Paragraph 20 of the plain which I showed your lordship refers to the report in final form, the final report 25th January 2021.
Correct.
That your lordship will find at page 63.
Yes.
Your lordship, please see the top final report, number 5 of 2021, then date 25th January 2021 at the top.
Correct.
Now, Lord, if your lordship please turns the page over, and Lord, please come to page 70. Your lordship will find towards the bottom of the page, Lord, the third last line, third last paragraph. So I am in an opinion here that here in this instant case, no criminality prevails. Though on the other hand, we can say that Limitation Act 960, clear trails, etc. Last paragraph can file a civil suit. So that is where it ended on 25th January. Then, Lord, your lordship will please turn the page over and come to Lord page 96.
So what has happened to this court?
Lord, this is the Naraji petition.
Naraji petition. The court has issued notice.
Yes, Lord.
After receipt of the final report, court has issued the notice. And on receipt of the notice, they filed the
Naraji petition. Lord, today
Naraji is still pending.
Lord, today I am to show your lordship, Lord, that as on the date of filing of the suit, cause of action for malicious prosecution did not exist.
No cause of action.
No cause of action for institution of malicious prosecution existed till the magistrate comes to a finding agreeing with the report of the investigating officer that no criminality exists. That had not occurred as on the date of filing of the suit. If it happens tomorrow, this suit becomes premature. They will have to institute a fresh suit. But as on the date of institution of the suit, the cause of action did not exist. Now, what are the steps that could have been taken or can be taken by the magistrate in this application? If your lordship please has a look at this judgment. 2004, volume 7, Supreme Court cases 768. Gangadhar Janardhan Matre versus State of Maharashtra. All the eventualities or options that are available to a magistrate on a final report being filed. Now, Lord, if your lordship is kind enough to come to Lord paragraph 8 of this judgment, or Lord paragraph 9, Lord. When a report forwarded by the police to the magistrate under section 173(2)(I), Lord, we are at the inception stage of the report having been forwarded to the magistrate now, and the magistrate having Lord accepted the Naraji petition on record. Is placed before him several situations arise. The report may conclude that an offence appears to have been committed by a particular person or persons, and in such a case, the magistrate may either 1. Accept the report and take cognizance of the offence and issue process, or 2. May disagree with the report and drop the proceeding, or 3. may direct further investigation under section 156(3) and require the police to make a further report. The report may, on the other hand, state that according to the police, no offense appears to have been committed, like in the present situation. When such a report is placed before the magistrate, he has again option of adopting one of the three courses open. That is, 1, he may accept the report and drop the proceeding, or 2, he may disagree with the report and take the view that there is sufficient ground for taking further proceeding, take cognizance of the offense and issue process, or 3, he may direct further investigation to be made by the police under section 156(3). The position is therefore now well settled that upon receipt of a police report under section 173(2), a magistrate is entitled to take cognizance of an offence under section 191(b) of the code, even if the police report is to the effect that no case is made out against the accused. The magistrate can take into account the statements of the witnesses examined by the police during the investigation and take cognizance of the offence complained of and order the issue of process to the accused. Section 191(b) does not lay down that a magistrate can take cognizance of an offence only if the investigating officer gives an opinion that the investigation has made out a case against the accused. The magistrate can ignore the conclusion arrived at by the investigating officer and independently apply his mind to the facts emerging from the investigation and take cognizance of the case if he thinks fit, exercise his powers under section 191(b) and direct the issue of process to the accused. The magistrate is not bound in such a situation to follow the procedure laid down in sections 200 and 202 of the code for taking cognizance of a case under section 191(a), though it is open to him to act under section 200 or 202 also. The informant is not prejudicially affected when the magistrate decides to take cognizance and to proceed with the case. But where the magistrate decides that sufficient ground does not subsist for proceeding further and drops the proceeding or takes the view that there is material for proceeding against some and there are insufficient grounds in respect of others, the informant would certainly be prejudiced as the first information report lodged becomes wholly or partially ineffective. Therefore, this court indicated in such and such that where the magistrate decides not to take cognizance and drop the proceeding or takes a view that there is no sufficient ground for proceeding against some of the persons mentioned in the first information report, notice to the informant and grant of opportunity of being heard in the matter becomes mandatory. As indicated above, there is no provision in the code for issue of a notice in this regard. Then, Lord, description of what is final, the charge sheet, final report, etc. So, Lord, if your Lordship please comes back to the plaint, Lord, in this application, we have asked for rejection of the plaint in terms of Order 7, Rule 11. We were asked for dismissal on some other grounds, which I shall come to. And Lord, also, Lord, on the territorial jurisdiction, we have taken for the suit to be dismissed. Now, Lord, so far as this, the Order 7, Rule 11 aspect is concerned, my prayer is with regard to the main relief, that is monetary claim on account of malicious prosecution. Only one paragraph is stated to be the cause of action. I've taken your Lordship to that paragraph which says cause of action arises by reason of filing of the complaint and the final report by the investigating officer on 25th January 2021. But my respectful submission is that does not give rise to the cause of action. As of now, it is in an it is inchoate. Even today, my lord, if the magistrate comes to a finding that no cognizable offence is made out and no criminality is made out, even then notice will be issued to me. I will be given a chance of hearing. That is what the judgment says. In fact, I have filed a Naraji petition also.
That is the thing.
That is on record. So, not in my respectful submission, so far as first aspect is
So what has happened to the Narajgiri petition? Pending or?
Lord, so far as I know, Lord, in this the investigating officer was directed to file a report. That report is yet to be filed before the magistrate.
Okay.
Lord, but I'll ask my juniors to get the order sheets out to show your Lordship exactly what the present situation is. I think by coming Monday, Tuesday, they will be able to give your Lordship the order sheets. But Lord, so far as this is concerned, Lord, on the date of institution of the plaint, certainly the cause of action had not arisen. It may at a subsequent point of time give rise to a cause of action when the suit may be filed, if at all, but not in this plaint. Now, Lord, I'll come to this is the principal judgment which gives, Lord, all the different options which are open. Now, my lord, there is one other aspect of the matter which I would like to take your lordship to.
Yes.
Now, my lord, please come back to the prayers, my lord. Page 34 of your lordship's brief, my lord.
Yes.
Now, the entire suit is really a counterblast to several proceedings between the parties, where it is alleged that money has been going from one party to another party in a circuitous manner. Your lordship, my lord, has been my lord, appraised of that by my junior on an earlier occasion. My lord, please come to prayer B. A negative declaration has been sought so far as prayer B is concerned. Declaration that no money is at all due or payable by the plaintiff number 1, or for that matter, any of the plaintiffs, to the defendant number 1 or any of the defendants. Now, my lord, I appear for the defendant numbers 1 and its director, defendant number 5. Now, in this application is filed on both on behalf of defendant number 1 and defendant number 5.
You are appearing for both?
1 and 5. 1 is the company and 5 is the director of the defendant number 5. Now, my lord, in my respectful submission, this sort of prayer, I'll take your lordship to the judgments. This sort of prayer is barred by the specific relief act.
No consequential prayer.
Lord, one is that no consequential relief has been claimed. Additionally, Lord, declaration in this negative form, Lord, is not permissible. Lord, this is one aspect of the matter.
Declaration that no money is at all due and payable by the plaintiff number 1 or for the matter of any of the
But why this has been couched in this form is that because the consequential relief would have been in the nature of an injunction. Injunction in this form would have been barred by section 41 of the Specific Relief Act. So they've kept the declaration without the consequential relief, which also gets barred. Now, this is my second argument. My third argument, Lord, is if your lordship is pleased to come to, Lord, page 31 of your lordship's brief. If your lordship sees this is where the cause of action arose. If your lordship please sees page 31, subparagraph G. The defendant number 3, along with his men and associates, came to the residence of the plaintiff numbers 2 and 3 outside the jurisdiction aforesaid and created ruckus just before Diwali of the year 2000. The said defendant, in order to coerce the plaintiffs to succumb to their unjust and illegal demands and threaten that in the event the payments as desired by them is not made, the plaintiffs number 2 and 3 will be taken into custody and in all likelihood shall spend the Diwali in police custody. The scene created by the said defendant has not only caused severe mental trauma to the said plaintiffs and has irretrievably tarnished the image of the plaintiff numbers 2 and 3 in their neighborhood and society. There are two submissions. But the first submission is with regard to the citers of the cause of action. The second submission, Lord, citers of cause of action, Lordship sees it's outside the jurisdiction, they say in the third line of G. This is where the incident took place outside the jurisdiction. No part is pleaded within jurisdiction insofar as the incident is concerned, where the ruckus is alleged to have taken place.
Yes.
Now, Lord, my second submission is, Lord, the allegation in G, which is the basis for the cause of action for paragraph 20, is not by my clients. Is by the defendant number 3 and his men and associates.
Defendant number 3 along with men and associates.
And his men and associates.
You are for the 1 and 5.
1 and 5.
Yes.
So, Lord, this brings me, Lord, firstly, Lord, to know the plaint insofar as the reliefs are concerned, having no cause of action insofar my client is concerned. Apart from no cause of action to institute in terms of malicious prosecution.
Correct.
Secondly, Lord, the leave granted under clause 12 of the letters patent should also be revoked.
Yes.
Lord, now, Lord, if your lordship sees that at the residence of the plaintiff numbers 2 and 3, That's the paragraph G, which I showed your lordship. Now, Lord, please come to the cause title.
Outside jurisdiction.
Cause title, your lordship will find the addresses are Bright Street, 4th floor, Baliganj, outside the jurisdiction of aforesaid 3 and 4 in the cause title. So entirely outside the jurisdiction that the incident took place.
Yes.
Now, Lord, the paragraph which deals with the cause of action in the plaint is paragraph 24. Now, your lordship will find that the only paragraph in paragraph 24 which deals with the cause of action insofar as malicious prosecution is concerned is paragraph 20.
So
paragraph 20 relates to G, which is outside the jurisdiction.
Correct.
The others deal with various other transactions, acts, and conduct which have nothing to do with the cause of action, which leads to the prayers.
Cause of action is stated in paragraph 5, 6, 8, 10 arisen within jurisdiction. 5, 6, 8, 10, 11, 12, and 13, 14, and 20. 20 is the same. 20 is with
20 is the actual paragraph.
Yes.
And 20 relates to G, because G is where the ruckus took place, etc. And they say that by that.
That is admitted outside.
Yes.
That is the admitted outside.
Yes. Now, Lord, if your lordship please comes to the other paragraphs 5, 6, 8, 10, I'll just take your lordship very quickly through that. Please come to page 24. Now, Lord, this relates to cause of action for money claims which have nothing to do with the cause of action insofar as this suit is concerned. So far as the decree for 10 crore is concerned. All the aforesaid payments were made by the defendant number 1 outside the jurisdiction of this honorable court into the bank account of the plaintiff maintained with HDFC Bank, Stephen House, within the jurisdiction. Under defendant number 2's covering letters, annexure B. Now, Lord, so far as the situs of the party's own bank is concerned, that is entirely the discretion of the party itself. Now, Lord, when a payment is being made to the party outside which is admitted. Made by the defendant number 1 outside. Payments were made by me outside. Now, he takes my money and he can deposit it wherever he wants. By that process, he can deposit it in Goa also. It does not mean because he has taken my money outside the jurisdiction and deposited somewhere else, that part will have cause of action. Question is, where did I pay? And the first line makes it clear all the aforesaid payments were made by the defendant number 1 outside the jurisdiction. The rest of it is not relatable to cause of action because the bank can be wherever the plaintiff wants. It's the plaintiff's own bank.
Honorable court in the bank. No. Defendant number 1 outside the jurisdiction of this honorable court into the bank account of the plaintiff number 1 maintain. So you have transferred the amount in the account of the defendant number 1 plaintiff. So your transfer, though you are outside, but the transfer in the bank which is situated within.
Now, banks can be situated now with core banking and with branches all over anywhere. The banks can be anywhere. The question is, from where am I making payment?
No, but there are judgments. If any part payment is made within jurisdiction, then it can be called as a
Here, the part payment is made from outside.
No.
And to a bank of the plaintiff which is within.
Within. Here.
To a bank of the plaintiff which is within.
Correct.
Namlord, if your lordship please see this, the document at page 43. I am writing saying that sum of rupees 4 crore has been transferred to you from our account in the following manner.
Correct.
And I am making payment of this from Bangalore.
Correct.
Now I'm making payment, my lord, to the account of the plaintiff, which is within, the bank is within jurisdiction. But I'm making payment from outside. Now, my lord, the question is, so far as I am concerned, payment is from where, in my respectful submission. Now, my lord, if payments are being made by the bank to me, it would be relevant to consider where the bank is situated. Now, the bank of the plaintiff can be anywhere. It so happens that it is there. But that is on the facts. It is a matter of coincidence that the bank is
No, but what you are claiming? Your claim was, as per the complaint, you have made the payment and they has not returned the
my first submission is these facts have nothing to do with the claim for malicious prosecution at all. That is my principle.
That is okay.
And that paragraph 5, etc., I'll show your lordship, has nothing to do with the cause of action. I'm secondly trying to demonstrate that in any event, my defaults have not occurred within the jurisdiction.
Okay.
If your lordship ignores this submission of mine, if your lordship feels that there is some difficulty in accepting the submission, lordship ignores it because it has nothing to do with my principal prayer that your claim for malicious prosecution is.
No, that's
nothing.
correct. Malicious prosecution, it's okay. With regard to the paragraph 20, still that report has not been accepted. It is premature. That is one aspect.
The next is on the territorial jurisdiction. Insofar as the territorial jurisdiction is concerned, also, my submission is that the allegation of the incident took place at Bright Street outside the jurisdiction. That way I went and created ruckus, his reputation was harmed, and then
that is outside. Okay, they admitted.
Right.
With regard to the paragraph 19G.
Now, the question is whether these paragraphs 5, 6, 8, 10, 11, 12, 13, 14 have anything to do with the cause of action for institution of the suit.
No, 5, 6, 7, 8, they may. I don't know what will be there. 5, 6, 7, 8, they may take the plea because for filing of the complaint by you occurs with the regard to the transaction of the amount. And the amount which has been given by the defendant to the plaintiff at the bank at Calcutta might be from Bangalore or might be from Bangalore. So the part payment or payment was received. So they may say it is continuation of the cause of action because the part cause of action arose in Calcutta. So if we go by, because if we go by the complaint, what is your complaint? The same thing, they have not written the amount and they have manipulated the amount. That's why the 406 and 420. So it is connected. So it's connected with the amount.
True, Lord. True. Lord, I'll address this, Lord. I'll address this part, cause of action insofar as the CRPC and cause of action insofar as CPC is concerned. I'll have to make that distinction for your lordship's consideration.
Then CRPC, that paragraph 19G and paragraph 20. That's okay. That is okay. See, in the CRPC cause of action where the incident arose. That's why the
action for malicious prosecution may be based upon any allegations in the complaint. It becomes irrelevant. The question is where did the incident take place? Lord, in a complaint which I may file before the police, I may have complaints related to several incidents having occurred in several places. Now, if a civil suit is to be filed on the basis of that complaint by me, I would have to take note of those individual incidents where they took place to get leave under clause 12 or under.
I understand you, but your submission is that the case is totally based on the criminal report.
The criminal.
Police report.
On the police report. Had I filed
not the claim of the money.
If I had filed the suit, that would have been relevant. Those transactions would have been relevant.
That is a different suit.
Yes.
Yes.
Now, Lord, 6 is also relatable to that. Lord, there is nothing here. 6 is only discussions. Lord, please see paragraph 6. Only relates to discussions between the parties. Because of the cordial relationship which the plaintiff number 1's management always had with defendant number 2, no other formal documents were made. All discussions, no part of the cause of action. Then 8. Subsequent investigation, it appears that the money is paid by defendant number 1 to the plaintiff number 1, where in fact monies which were received by the defendant number 6 from the defendant number 7, admittedly a company under the control of plaintiff number 2, defendant number 2, a chart is given. All the aforesaid payments were made by defendant number 7 to the defendant number 6. Lord, nothing in this paragraph is relatable to me, Lord.
This is a transaction.
This is a transaction between Lord defendant number 7 and defendant number 6. Inter-party transactions with defendant number 6 and 7, they may have a cause of action so far as other defendants are concerned. So far as I am concerned, Lord, there is nothing to do with my clients, Lord. Then, Lord, please have a look at paragraph 10. Money is received by the plaintiff number 1 from the defendant number 2. Through the defendant number 1 carried interest. Tax has been deducted at source on the interest component by the plaintiff number 1 for the financial years 2017-18 and 18-19 and deposited with income tax authority within the jurisdiction. That's no part of the cause of action. The citers of the income tax authority is no part of the cause of action, Lord. Lord, the next paragraph is paragraph 12, Lord.
Yes.
This is absolutely absurd, Lord. Plaintiff number 1 accordingly awaited instructions from the defendant number 2 to effect repayment. Defendant number 2 thereafter by his letter instructed the plaintiff number 1 within the jurisdiction aforesaid to effect repayment. That has nothing to do with the cause of action. Where he has come and given me an instruction that you effect repayment, that has nothing to do with that. Then Lord, paragraph 13. Defendant number 8 received payment from the plaintiff number 1 within the jurisdiction aforesaid on behalf of defendant number 1, which has been confirmed in writing by letter dated such and such. Letter was received by the plaintiff at its office within the jurisdiction aforesaid. Now, this would have been a material paragraph in my suit, where I would have to show that this was not part of cause of action, or if I file the suit here, this would have been my part of cause of action. But for a malicious prosecution, this is no part of cause of action.
Okay.
Lord, paragraph 14 and 20, Lord, I don't need to show Lordship, 14. Again, this is payments made within the jurisdiction.
The same, RTGS.
If I am claiming payments have not been received by me and I'm filing a suit for recovery of monies lent and advanced, then these are part of my causes of action. But in a suit for malicious prosecution, these are not part of the cause of action. In a civil suit filed for recovery of monies lent and advanced, or for recovery of monies due, this would have is a part of cause of action.
Yes.
But not in the counter suit filed for malicious prosecution for complaint made by me before the police, Lord. Look, the only other paragraph is paragraph 20, which I've shown your Lordship. Paragraph 20.
Okay.
Now, Lord, I'll come to the judgments and Lord declaration and Lord whichever day your Lordship Lord wants to keep it.
So offering for the plaintiff, so offering for the defendant. Defendant has filed an application being GA2 of 2022, praying for rejection of rent. Counsel for the defendant has argued at length, but due to paucity of time, hearing could not be completed. How much time will take, Mr.?
Half an hour.
I am fixing 2 dates. Then it can
Very
let the matter up and give the 2 dates.
only that after Mr. Sen completes, I'll need some time to prepare because we'll have a leader in the matter. So may not be consecutive days. 2 days may be fixed, but not consecutive.
Very great. 19th February at 3:45. Yes.
Interim order for item number 46.
Item number?
46.
46
is there and the interim order.
46 of today's list?
Yes, my lord. Non-commercial.
Who is for the defendant?
Lord, I've given the notice, my lord.
None of person suffering for the plaintiff. Though the matter is listed as item number 46 in the today's list, but due to paucity of time, the matter could not be taken up for hearing. Counsel for the plaintiff mentioned the matter and submits that the interim order granted earlier is going to be expired today and paid for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 26th of February 2025 or until further order, whichever is earlier, let the suit be remain in the list.
My lord, may be permitted to mention a matter. My lord, this is my suit. The interim order is expiring today, my lord.
Listed today?
It is not listed. It is listed on 17th of February, my lord. 12th of February, my lord, sorry.
Since appearing for the plaintiff and submit that the interim order and submit that the interim order granted earlier is going to be expired today and paid for extension of the interim order. In view of the when the matter is fixed?
12th of February, my lord.
Submit that the suit is fixed on 17th of February.
12th February, my lord.
12th of February 2025. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 14th of February 2025 till 12th, till 14th of February 2025 or until further order, whichever is earlier.
Grateful, my lord.
Yes.
My lord, item number 41, my lord.
Yeah.
This is my suit, my lord. The interim order, my lord, is expiring today, my lord.
Huh?
Interim order, my lord, is expiring today, my lord.
Today?
Yes.
41. So. Who is for the defendant?
My lord, Mr. Anirban Bose, my lord, usually appears, my lord.
Have you informed?
No, my lord.
Mine, Mr. Anirban Bose is there. So appearing for the plaintiff. The matter is listed in the day's list at item number 41, but due to paucity of time, the matter could not be taken up for hearing. Police counsel for the plaintiff submitted that the interim order granted earlier is going to be expired today and paid for extension of the interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 20 February 2025 or until further order, whichever is earlier, let the matter remain in the list.
Milord, liberty to mention, Milord. That is item number 104, Milord. Petition
104?
104, Milord. Non-commercial, Milord.
104 of testamentary?
Yes, Milord. Milord, petitioner is seriously ill, Milord. Kindly fix up the matter, Milord, at any day, Milord.
Huh?
Milord, petitioner is seriously ill, Milord. Therefore, Milord, I am praying for fixing the matter at any day, Milord, any time, Milord.
Come in the morning. This also mentioned. This is only the interim order.
My lord, I apologize.
Milord, tomorrow
My lord,
morning.
item number 65.
Tomorrow mention, we'll see to that.
My lord, item number 65. My lord, I could not assist your lordship, my lord. I apologize. My lord, the affidavit of the attesting witness was there.
So what can I
Lordship,
asked several times? You stated that only the consent that declaration is
Lord,
there.
it was there separately. It is entirely my fault.
No, are you check the record in the record?
My lord, it is there, my lord.
It is with you, not in the court record.
My lord, I'm told it's with the court records. My lord, kindly keeps it up on, takes it up on Friday.
You mentioned tomorrow. Let us see.
My lord, tomorrow is a. I'm grateful.